Hyundai Tucson versus Toyota RAV4. Look what
There's a wait list until the first week of March. So we're asking for a reset until mid-March.
So when specifically in March?
Well, it's the last week of February to the first week of March, so I guess the second week of March.
Okay.
That would work.
Oh, and where is Mr. Daryl Harris was here, and then all of a sudden he's not here anymore.
He's right there, Judge.
Oh, Daryl, come forward, Mr. Harris. I didn't see you. You were blocked. Blame Hank.
Might be of service.
All right, so they're telling me that Veterans Treatment Court has a wait list, which I do believe, and they're saying that they'll be available sometime in March because he's been accepted.
He was just accepted not past week. I will trust counsel. We staff the number.
So my question though is, and what I'm concerned about is he's been accepted. I'm going to give you your March setting date, but I want to make sure that between now and March, he has, contact with who he needs to have contact, because I don't want him to fall off and start doing things that perhaps he shouldn't be. I don't want him to be in the world without access to treatment. So what I'm going to do is I'm going to reset it for March, and then Mr. Harris, you all going to discuss and make sure that he has his everything set up for treatment. See, I delegate.
We'll make it.
Thank you. So what date in March?
I think you're the 7th or 14th.
7th or the 14th?
The 14th is better.
All right. So what, March 14th? Oh, I'm going to be here anyway, because we'll be in jury trial. Right. So March 14th, but since we'll probably be in jury trial, I'll need you to be here exactly at 9 a.m. Okay?
Thank you, Your Honor.
All right. Thank you. Once you sign the reset form, you are excused, and please confer with Mr. Harris.
I will.
All right. Thank you. Jacob Sanchez. All right. So what's happening with this case?
I'm just talking with defense right now is that the state's made an offer on the case.
Okay.
It's good.
All right. Defense, do you have all the discovery?
I believe so.
Sir, how old are you?
I'm not sure. I was born in 1988.
Okay. And you don't know how old you are? All right. Is there you need to say yes or no. You don't know how old you are?
Oh, no. January 11th, 1988.
All right. So have you had any mental health issues or anything of that nature?
I received medication.
All right. What do you receive medication for?
It sold something. I'm not sure.
All right. Are you currently
Right now,
on medication at the gym?
this one.
All right. Counsel, you're aware that he has, at least he's presenting to the court, that he has some mental health issues?
I am now.
All right. Do you think your client is competent? You want to speak to him about that?
No, I don't. I think he's not competent.
I'm sorry, what?
I believe he needs to be examined for competency.
All right. Did you speak to him about competency issues? Because And I'm just asking because when you all became before me, nobody mentioned competency until I mentioned it. So have you discussed with him his mental health issues?
No, I have not.
All right, if you want to speak to him about that, then you all can reapproach.
Okay, thank you.
All right, thank you. Who's it?
You're in the middle. You're in the middle. Mr. Anton, you're on this side.
Oh, excuse me. Yes. I don't know why he came.
Mr. Anton,
Oh,
on this side.
Yes.
well, that's just normal, Judge.
All right, court is calling 2023 CR 10327, State of Texas versus Andrew J. Garcia. Could I have parties announced for the record for the state
What's Maru for the state of Texas?
defense?
Anton Hike for the citizen appeals.
Are you Mr. Garcia? All right, so no paperwork on top of the court reporter's desk. Thank you.
Yes.
All right, counsel, have you received all the discovery and did you review it with your client?
I believe the state has given me all the discovery I'm entitled to, including 3914, and I've reviewed it with my client, not only today, but other times.
All right, the court will find that the state is in compliance with discovery. Everyone, if you're behind the court reporter, don't speak. Counsel, if you need to speak to your client, they'll move you to the end. All right, Mr. Garcia, I'm showing you what's entitled, well, I have two. I have an application for deferred adjudication and an application for community supervision. Did you review those with your attorney? Did you understand it? And did you sign them?
Yes, ma'am.
All right, next I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We waived the reading.
State, are you proceeding on the indictment as presented?
1 through 4.
All right, and each count is the charge official oppression.
Yes, 1 through 3 are official oppression, Judge. 4, I believe, is a tampering with the government record.
Okay. All right, and then are you waiving count 5, 6, and 7?
Yes, sir.
Any objection?
No objection to waiving those things.
All right, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? All right, did you understand in counts 1, 2, and 3, you're charged with the offense of official oppression? And count 4, you're charged with tampering with the government record. Did you understand?
Yes, sir.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand each one of these counts are state jail felonies? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, sir. I'm sorry.
All right, so you don't have the proper paperwork before me. I have here, this is state jail felony paperwork. So the record can be clear, what needs to be done is court admonishments. You need to fill out the different document and you need to fill out each count in the range of punishment for it, because otherwise this document listed all as state jail felonies. So if y'all will do that and then approach and we'll take it up. All right, thank you.
Oh, my God, here we go.
The Kardashians have redefined the American dream.
We're going to go back on the record in cause number 2023 CR 10327, State of Texas versus Andrew Garcia. Can I have parties announced for the record again for the state?
Anton High for the citizen appeals.
All right. So I've previously asked the defendant if he reviewed the indictment. State, are you proceeding on the indictment as presented?
No objections.
And counsel, do you waive the reading of the indictment? All right. Showing you again what is entitled court admonishments. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand in count 4 you're charged with tampering with the government record? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty. Excuse me, don't talk behind the court reporter. You can move it to the end. If for any reason the court were to revoke your deferred adjudication and find you guilty, the court could sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
I certainly do believe that.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, state is proceeding on count 4 only. Is that correct, state? Punishment is to be assessed at 1 year in the state jail facility. They're opposing your application for deferred adjudication. They're recommending community supervision, and there's to be a permanent surrender of your T-code license. Did you understand that to be the plea? Defense, is that the plea? State, is that the plea? Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions? Next, I'm showing you outside the agreement. The state is requesting that your deferred adjudication be for a term of 3 years. There be no contact with. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged in count 1, how do you plead? Guilty, not guilty, or no contest? State, any evidence? Any objections?
No objections, Your Honor. We've looked over today.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, March 7th at 9 a.m. All right, is there anything else? Yes,
Does he see a probation?
yes. Diane? All right, counsel, does your client need a competency
I
evaluation?
believe he does.
All right. And you're going to be filing that?
Yes, I can send it, I'm going to send that with you or you.
Oh, you can file it here in the court. Ms. Ferguson, I need a reset date for a competency evaluation.
I'll do the March 17th.
Well, can you put it in February to make sure it's filed? All right, February 29th. So it needs to be filed today. And we'll be back on February 29th. And Ms. Ferguson, if you can give Mr. Sanchez a reset form, because I think this is the only thing that's holding him. All right, is there anything else? All right, thank you. On this case, I need a 3-week reset for plea deadline date. All right. All right, counsel, have you received all the discovery in this case?
I have your own.
All right, has an offer been tendered?
Yes.
All right. Then this is going to be set for a plea deadline date, and that plea deadline date is going to be on February 6th. Mr. Padilla, at that time, you need to let the court know whether or not you're accepting the state's offer. If you choose not to accept the state's offer, then this will be set for jury trial, and your plea deadline date will have expired. The court will only consider a plea bargaining agreement with a good cause. Otherwise, you'll have to plead open to the court. Do you understand?
Yes.
All right. Do you have any other questions?
What would be the sentence if I was found guilty?
All right. According to, I believe he's charged with aggravated sexual assault. All right. The range of punishment for that offense is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. All right. Thank you.
Thank you, Judge. Your Honor.
You're welcome. All right. Is this a plea?
Yes, ma'am.
Can I have a stamp? Court is calling 2023 CR 4167, State of Texas versus Norma Elizondo. Can I have parties announced for the record for the state?
Miguel Hernandez for the defense.
All right, and are you Norma Elizondo? Counsel, have you received all the discovery and did you review it with your client?
Have your honor.
Court will find that the state is in compliance with discovery. Ms. Elizondo, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, your honor.
State, are you proceeding on the indictment as presented? Ms. Elizondo, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Do you understand you're charged with assault, intentionally and knowingly, serious bodily injury by omission to a child? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? The court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain agreement. Did you review that with your attorney? Did you understand it? According to the plea, the punishment is be assessed at 30 years in the prison and there are no applications. Did you understand that to be the plea? Defense? State? Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence
We had a chance to review, Your Honor, no objections.
showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are.
All right, and what is the current condition of the child?
She is in a.
All right, the court will follow your plea bargain agreement, sentence you to 30 years in the prison, give you credit for any time served. Is there anything else with regards to sentencing? Can I show you what's entitled trial court certification of defendant's rights to appeal? Did you review that with your attorney? I'm sorry, one other thing that I'm going to add to her sentencing is there is to be no contact with minors. I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Mm-hmm.
All right, good luck to you. Thank you. Bring that.
Order. There was no modifications to his conditions at the time.
Okay.
The only modification was in regards to his GPS. So,
So with regards to his GPS, have there been any violations or anything?
not that's notated, Judge.
Okay. All right, Mr. Aceves. Aceves.
He's never had his violation since day one.
Okay.
I can get you a copy of that even back in a minute if you like.
Oh, no problem. You're an officer of court, and I know you, Johnny. I trust you. All right. How's everything going?
Pretty good, man.
All right. So how are you spending your time? What are you doing?
I spend it at home with my family and try to look into for a job and all that.
All right. How's the job search going?
Pretty well. I'm still waiting for an interview for the construction business, and I don't know if I'm gonna get a call this week or the next week, but maybe if I be able.
All right. Just 1 second. Excuse me. If you all can't whisper, then you're all going to have to confer outside.
Daniel,
So we'll be able, try to look for another job since they do not contract me.
All right. And so are you doing school or looking into school or anything of that nature?
Not right now. I'm looking just for a job right now.
Any type of trade school or
Also,
trade school or anything of that nature? What are you planning on doing with your future?
for a GED.
So you said GED? All right. Have you started working towards that?
Say yes, ma'am, or no, ma'am, we should answer the question.
No, not right now, man.
All right. So it's probably best if he starts trying to get his GED if he doesn't have it.
Yes, ma'am, that's what you're working on, correct? Trying to get your GED? Okay.
All right. So his GPS, what is the status of that? Is he on tracking or does he have scheduled
I
set
think
up?
he still has a full house GPS for the first 3 or 6 months.
Mhm.
And then after that, we're gonna reevaluate, I believe, if I remember correctly.
All right. It's been 3 months.
Yes, ma'am. But I think it was 3 months, but I'm not sure. I don't want to lie to the court.
No. Because I think it's time for him not to be on full GPS.
Your Honor, in December, the conditions were modified for partial GPS,
Mhm.
and there's not been any violation.
All right. And so then we said partial, I believe, I guess I probably said partial for work or to look for work.
Employment and mandated class.
All right. So are you okay with loosening that a little bit to giving him some extra time or no?
Yes, I do see that, we have been in communication with this in regards to, certain job fairs and so forth. He's in compliance with all of his field visits, reporting on time.
So I think,
Judge, if we put him on track and he can go out and look for other jobs, he can stop at job sites and things.
well, I think what I'll start with, because now it's just partial. I'll start with him being allowed to do things in certain hours. So if it's not work related or if it's not for classes, I'll allow him to be out and about till 6 p.m.
Okay.
That means that you'll have to be at home at 6 p.m. Now, if you're at work and your work schedule takes you beyond 6 p.m., that's fine. So we'll start with that. And then the next time, if there are no issues, then we'll start with tracking only and then hopefully move towards removal.
So from what time to what time? I know from till 6 p.m., but what?
We'll
time?
do it Monday through what day? Do you want Monday through Friday or Monday through Sunday?
Judge, we don't have any, I would say Monday through Saturday.
All right. Monday through Saturday, we'll do 7 a.m. to 6 p.m.
6 a.m.
7 a.m. to 6 p.m.
a.m. to 6 p.m.
Okay, you want 6 a.m. to 6? Okay. She's
That
fighting
way,
for you.
just in case he gets a job to where he has to, you know.
All right, so your GPS now will be 6 a.m. to 6 p.m. That's whether you're looking for employment or whether you have a class or not. If you want to go to the park, then you can do that. So that's from 6 a.m. to 6 p.m. If there is something where you have employment and that employment takes you outside of that window or a class takes you outside of that window, let probation know.
Okay. Yeah, I will notify them if it takes longer than 6 a.m. 6 p.m. Sorry.
All right. So then what we'll do is we will see how that goes and we'll come back in 3 months. And in 3 months, it'll probably, if there are no issues, then it'll probably be tracking only. And then 3 more months, if there are no issues and nobody objects, it'll probably be removal.
Good. Just yesterday, it just happened that I got a call from an old client.
Mhm.
He owns a house framing business.
Mhm.
And he had some traffic tickets, so I went to pick up the money, pay the tickets. I'm gonna call him and see if he can use them.
Okay, awesome. Thank you. Johnny, you're so awesome.
Well,
I've known you forever. I've known you when I was a defense attorney and a prosecutor. You're just awesome.
well, thank you. So are you. It's fun. I love coming here.
Oh, thank you. So Norma, on this case, if you can give me a date to come back in 3 months, April 4th or April 11th.
May I look at the phone?
Sure. Or if you want a date other than that, just let us know.
Your Honor, while he's looking at his calendar, as far as the mental health treatment is concerned, are we okay just to monitor at this point? And if anything arises, let the
Yes.
court know?
We'll monitor. And if there is some issues that you're having, be sure to let your attorney know and let probation know, because we can't help you if we don't know.
Okay.
And the last thing you want to happen is something that happened, and then you come back to this court and saying that you didn't tell anybody, because in this court, I believe that communication is key. When I place people on probation, I want them to be successful. So you have no excuse. And if the probation officer, who is your probation officer, is not addressing some issue you have, you can always call your attorney, or either you can always come to court.
Right, we'll do, ma'am.
All right.
April the 4th, Your Honor.
All right, Norma, we're going to call this back on April 4th.
After you finish.
So let's continue for the agreement which I say is to release.
Okay.
The lady and the announcements, okay.
You taking under?
No, it's in hold.
Okay. All right, anything else that's needed?
He's wondering about subject matter under communication. Something about ankle management, but I don't use it for anything about ankle management.
Let me see. I don't have anything listed on the docket sheet that he's supposed to do anger management classes.
They say it was on hold until something happens or something like that.
Oh, so it's in abeyance? All right. Bashan, he has some concerns about his conditions. I don't have him down for anger management, but he thinks the paperwork he's reading says that maybe it's in abeyance or something. If you could review that.
Yeah, I don't remember anything. It's not there.
Yeah, have anger management held in abeyance.
All right. So yes,
That
you
was
don't have
on
to.
his original conditions.
All right. So you don't have to do that.
Not yet. You don't have to do that. That's why it says that. Okay.
And I don't know if Johnny would like to talk to you about that. Yes. All right. Is there anything else?
No, Your Honor.
All right. Thank you. Good luck to you. Thank you for the good work.
Thank you, Your Honor.
Okay. Thank you. Thank you, Your Honor.
All right. Thank you. Have a good one.
Yes, ma'am, you too.
All right. No, this is done. Kelly Cotner. If you'll come forward.
We conferred, Judge.
All right. All right, so she's provided an affidavit of non-driving. So what type of device do you all want her on?
Scram, Judge.
Okay,
Now, Judge, she currently has an ankle monitor GPS tracking, and she's under house arrest. And rather than have two monitors, we're asking that it be partial house arrest so that she can take care of business, and including visiting with me, because it's time, there are time constraints. And I don't want to have to deal with that.
I'm not the one who put her on GPS. State, are you ready to address GPS issues?
Yes, Judge. In talking with Mr. Sharma, I guess the state has a number of questions. Mr. Sharma's related that he has a number of business interests both in this county and out of county. I just wanted to maybe see if we can get more information on that before making a decision to switch to partial. And I kind of understand it's more to do with land and other litigation in other counties. Is that correct?
All right, then what I can tell you is I'm not going to address the issue with GPS as far as removal. But of course, with GPS, she's allowed to visit her attorney. And I will place in this order, defendant allowed to visit her attorney for legal matters. And then any other issues with GPS, you all need to file a motion. I will hear it.
I think we've already filed a motion to modify. Yeah, and
Okay, I don't have that. If you want to go to back and have them pull it. State, are you ready to have that heard?
Yes, sir.
All right, so if somebody will pull that motion for me, I will hear it.
okay. Get the file and bring it to you.
Yes. Well, there is no file, but there should be a motion.
Okay.
Sarah Gutierrez. Hello. So where are we on? Hello.
Hi.
So where are we on the eval?
It's going on, I think, the 17th of this month.
Okay. Okay. And who is it with?
Dr. Smith.
Okay. All right, Norma, if you can give me a reset date for 45 days.
Do the 22nd. February 22nd.
All right, we'll come back on February 22nd. By then, hopefully I'll have an update on the evaluation. Make sure you make that evaluation, okay?
Yes, ma'am.
All right, once you sign the reset form, you're excused.
Thank you.
All right, thank you for dressing appropriately for court.
Of course. Thank you. Have a seat. They'll take it to me. Thank you.
You're welcome. Is the attorney here on Lucio Roa?
Judge.
Yes. Norma, can you call Hagee? Officer Hagee? All right, Tony Torres. Good morning. Counsel, you're on the other side. All right, this is your third violation report. So it says that your device has not been calibrated.
Judge, I spoke to my client about that. I will tell you, he has some memory issues. He has some mental health issues that are going on. According to him, he's never been informed that he needs to calibrate it each month. I've explained that to him today.
Okay, I know he's been informed that he needs to calibrate it.
I've told him he needs to start writing things down if he's not remembering what his pretrial officer or anybody else is telling him. As far as I know, he's been testing negative for all drugs, any alcohol. He's been on random UAs the whole time. He tells me he's not drinking. So it is his third violation. The two previous violations were a delay in getting the device installed. He does not have a vehicle, so we had to appear before you to get an in-home device authorized. So he hasn't been tested positive for alcohol, Judge. I have told him there are rules that he needs to abide by, and if he can't remember them, he needs to write them down. But we're set for a plea hearing next week. I anticipate getting it disposed off of your docket. I'm asking you to keep this.
Can we get it disposed now? State is here, file is here.
I haven't reviewed the videos with him. Yeah, Judge.
All right, if you all want to review, State, do you have the videos down here?
I get downloaded from Judge.
I have them in my possession, Judge. I'd like to review them in my office. That was the plan, was to meet with them this weekend, come back on Tuesday, let him decide if he wants to plead or go to trial on the case. I have two other settings in two different district courts today, and I have a misdemeanor case. So if you can give us until Tuesday, you know, he's told me every single time, I'm not drinking, I'll test negative for anything. I think it's just a matter of logistics, not
All right.
violating his bond conditions.
So I understand what you're saying, but a lot of people say that they'll test negative and they're not drinking. But then they get tested and it turns out they're drinking. State, do you have anything to say with regards to this violation?
Well, Judge, this is the third one. We confirmed the defense and we thought we'd leave it in your hands. I know that it's set for next week. We have made it on, so we can review it. We were thinking maybe the SRAM might be appropriate, but I don't know if he's going to get that installed before we set it.
Mhm.
So, it's a third violation. Judge.
All right, I'm gonna have you all come back at 1:30 and you can watch videos with him over the break or either before. So I'm gonna make my ruling on this at 1:30. So everyone comes back at 1:30. Okay, sure. Norma, this case is coming back at 1:30.
Yes, ma'am.
Yes.
All right. Diane, are you ready to go on the record?
Yes. He was
Court is
pointing out-
calling.
He's talking,
Yeah, are you all ready?
Judge, just one more.
All right, sure.
bringing something out.
Okay.
When you come back, I can follow you. Okay. Well, I'm looking to see. Okay, thank you. Also, as soon as you can come back.
Jasmine Gallegos. Devin Strike.
Here, Your Honor.
Jeremy Duke. Jeremy Joseph Duke.
Not here.
Jesus Trevino. Michael Ugui. John Lyles. Mark Hernandez. Jason Wilson. Andrew Arnett. Jasmine Gallegos. Yes.
I called a friend of mine, doesn't need anybody, but I called another friend, and he's gonna hire him.
Oh, awesome. Jenny, you're so awesome.
It's the biggest cabinet making company in San Antonio.
Oh, that is so great.
So I'm gonna take him to interview.
Wow. Oh.
And he said, if you recommend him, I'm gonna hire him. So I'm gonna take him, I can't today, but tomorrow I'll take him over there and he's got a job.
Oh, that is so awesome.
Okay.
Thank you, Johnny. Saving people one person at a time. I like it.
I believe in this, man.
I do too.
Yeah, I know you do, I can tell.
Yeah.
And he's doing good. I mean, he just said the wrong thing.
Yeah.
So anyway, I'll let you know. about
Oh, hey,
that.
awesome.
Okay, bye-bye.
Thank you. And Michael, on that case, I know they're asking for GPS, correct? So I'm going to end up granting that. I don't know if you're going to, and then if we're able to have a hearing on your client and I figure out what's going on and it needs not be there, of course, I'll recall that. Sure. But I don't know if you want to confer with the state over that.
The only thing is, time-wise is just,
Oh, no, I
I am
understand.
thinking that Eve this morning and then another 144, so.
Okay. No, I mean, I'm going to have to rule on that now.
We confirm that, we confirm. Thank you. Let's another matter.
Yes.
With our bond reduction, the state had an offense report. I don't know if you want to read that beforehand.
Yes.
Instead of us sitting around. Thank you.
Okay, in which case is this?
This is for the.
Virginia Cerna.
All right, is Virginia Center, can you have it brought out?
Yeah, we'll get it.
And I'll read this. Yes.
The state wanted to introduce some police reports, and I kind of object to that because you're the trial judge. And so what I'd like to do is maybe have this assigned to the magistrate.
I'm available to hear bond matters. So this is what the court is going to do. Ms. Kotner, Hockner, will you come forward, please? So I'm going to continue on GPS. I'm going to order the scram and the removal of the ignition interlock requirement. And I've notated on the sheet that you provided an affidavit of non-driving. You have 2 days to comply with Scram Counsel. If there is some issue with them not being able to set up an appointment with her with Scram, let the court know. But for now, it's 2 days to comply. Of course, you'll be allowed to meet with your attorney. And with regards to the GPS, if y'all want the court to hear it today, I'll hear it today. If you don't want me to hear it today, then pick a date for me to hear it. All right?
Well, the same issue is going to be here.
Yeah, so the question is, do y'all want me to hear it today or not? If y'all don't want me to hear it, then we won't hear it today. If y'all want me to want this GPS heard, then I will hear it today. Otherwise, talk to the coordinator and she'll put it on the docket for this court for another day. So just let the
you
court
will
know.
not send this to a magistrate.
No, everybody's here. I'm here. State's here. We can hear it.
I understand that, but I object to the evidence that they want.
All right. So, Ms. Ferguson, Ms. Cotner,
Yes.
can you set this for a bond hearing in this court with regards to GPS? And give it some day next week. Y'all will be ready next week?
I'll be in trial next week.
All right, just pick a date with Ms. Ferguson and she will give you the date and we'll hear it.
Okay.
All right? Thank you, Judge. You're welcome. Thank you for dressing appropriately for court.
Do you want to take that or do you want
Yeah, if I can hear it.
And Norman, on this, we need to make sure that regional services have it because otherwise they'll continue to say they don't have her affidavit.
Judge, is she excused now?
Well, Norman's going to give you all a date to sign a form.
Okay.
No, that's good. Oh, yeah, it is NIMAC number 740266.
We're picking the jury on Monday and then
Monday's holiday.
Tuesday. And then, I don't know how long it's going to take, probably.
No, this is the first.
And counsel, you put in your motion for her to have the scram on or about the January 15th. And so the court's order for the 2 days is within the time frame you requested.
If I have an appointment for her within 2 days and they can't get to it, can I just present that to the court?
Oh, yes, but your appointment should not interfere with them putting the scram on her.
The appointment won't interfere with?
No, that your request for her to meet with you should
No,
not
no, no, no.
interfere with her scram.
What I'm saying is that if, say, she wants to get a scram, they said, well, we can't get to you for 5 days.
Oh, yeah, just let the court know.
That's what I'm saying.
Sure.
Okay, I don't want to get in trouble because she doesn't have it. If they don't.
No. And I'm sure they'll have it though. Wilfredo Salinas.
There's something for her to sign.
Hello. All right, they were just bringing you out. Have you had a chance to speak with your attorney? All right, so Mr. Salinas. Okay. Yeah, I'll put him in the box. Deputy Laura, they're not ready on Salinas. Hi, you're here for Salinas?
Yes, yes.
This is his attorney, and so we'll put it in the box. Norma? I thought she was back. All right, no problem. Norma. All right, thank you. Yes, hi. All right, just give me 1 second. All right, yes. Yes, yay. Mhm. No, he's on the docket, but I told him not to bring him over, just so we can figure out a date. Okay. Can I see the phone? Mhm. All right, yeah, it's just for her to be here, not her client, because I know he's not gonna be over the illness. But if you want to take it up now, we can. No, we can take it up now if you want to, because it's just to get a date. Okay, sure. Mr. DeLeon, whenever you're ready on your client, Virginia Serta.
All right, Judge, we're ready to go whenever you are.
Okay.
Yes, you have a couple minutes.
Sure. Can I see the file on Virginia Serta? And Mr. DeLeon, this is a motion for bond reduction, correct?
It is, Your Honor.
All right, can I see the motion for the bond reduction, Ms. Ferguson, if y'all can pull back? No. Okay, thanks. And Mr. DeLeon, I'm assuming it's going to be a jury trial for the aggravated assault?
Yes, Your Honor. In fact, we would like to, after the hearing, should we expedite that?
Yes.
Judge, I'm sorry, is the, motion to join the record?
Yes. That's correct. You want the bond reductions on the CM cases, correct? Well, unless the state has witnesses for the aggravated assault, there's going to be a bond set, since the rules of evidence will apply in that case. Deputy Law, where's Mr. Lucio? Oh, okay. I know you do. I'm testing my memory because I didn't see him over there.
I need the state, so there's a trace that.
Yeah. All right, Salinas. Wilfredo Salinas.
Salinas.
Who is the prosecutor on Wilfredo Salinas? All right. So where are we on discovery?
First setting, the state was going to ask for time to reach out to the employee.
All right, and Mr. Salinas, are you a citizen?
No.
All right, does he need an immigration attorney appointed?
Not at this point in time, I don't believe, Your Honor.
All right, so are you going to handle his immigration issues?
Well, we just have the criminal side of it right now. Is he, all right,
No, he's going to need an immigration attorney.
okay.
So are you all retained?
Yes, we are.
All right.
Before it is necessary, they can go ahead and start the process.
Well, no, are you all going to pay for him to have an immigration attorney?
No, we're doing the criminal side of it. We're just doing the criminal.
No, I Well, the reason why I asked is because legally, immigration issues have to be addressed with him because he cannot enter a plea without someone telling him the consequences.
Yes, I'm certified as an immigration law attorney as well, Your Honor.
Okay, all right.
However, I don't think he's gonna be pleading right now.
No. I don't want anything to hold up this case. I don't want us to have a jury trial and we can't go because the immigration issues have not been addressed. So you're going to address the immigration issues as it relates to this case with him?
Yes, ma'am.
All right, thank you. All right, Ms. Ferguson, on Wilfredo Salinas, if I can have a 30-day reset, please.
Your Honor, I have a quick request as well.
Yes.
I didn't get information as to whether or not an amount this bill has been set for Mr. Salinas. Is there any way we can get that amount set here, or do we have to set a separate hearing?
Oh, no, you just file a motion and we'll hear it if there is some bond issues. So you just file the motion and we'll hear it.
Okay, so I don't know if the amount set now will be considered to be an excessive amount.
Oh, if you all think that he can't pay that, then if you want to file a motion for a reduction of bond, the court will hear it.
Okay, all right.
Okay, thank you. All right, we'll come back on February 12th. And yes, and Norma, Mr. Salinas is not a U.S. citizen, but his counsel is telling me that he will handle the immigration issues as it relates to this case. All right, is there anything else? All right, thank you. Yes. Do you know, is there an ice hold on him? Counsel, do you know if there's an ice hold on him?
I'm not certain whether or not there is one. I can check into that, Your Honor, and I can send it in.
All right, yes.
Thank you.
All right, thank you. Have a great day.
You too, Your Honor.
May I return? Yes. Whatever. Sure. And whenever you all are ready on Cerner, just let me know. Yes.
Yes, there's not.
All right, thank you. All right, state. Daniel, on Wilfredo Salinas, there's an ice hole. So this case is going to have to move very quickly. Otherwise, they're going to take him. Yeah, some people say that solves the problem, but then some people say it just complicates things.
Is it like this swallowing a spider to get the fly?
All right, thank you. All right, are you all ready?
I think we're ready, Judge.
Okay. Who is the prosecutor on Virginia Serna?
Thanks, you, Judge.
All right, so Mr. DeLeon, your motions are lost in the system somewhere.
Sure.
So are you all okay with proceeding without his physical motions?
Yes, ma'am. Judge, you can approach this on the conditions of bond that have already been put in place.
We're going to go on the record. Court is calling CM 114217, 114220, and 114222, State of Texas versus Virginia Serna. Can I have parties announced for the record for the state?
Hey, welcome to the state, Your Honor.
Michael DeLeon for Ms. Cerna.
And are you Ms. Serna?
Yes, ma'am.
We are here, counsel, for a bond reduction. Is that correct?
That's correct. Just for the record, Your Honor, originally Ms. Cerna was charged with aggravated assault with a deadly weapon. Her bond was set at $15,000. That occurred early in 2023. She in late October of 2023 picked up 3 charges of aggravated robbery, which we very much dispute. And because of those robbery charges, her original bond on aggravated assault was remanded without bond. Okay, so today we're going to.
Just one moment. And the court will also be calling 2023 CR 5815. You may continue, counsel.
And today, Judge, we're going to be asking that a bond be set in her aggravated assault charge, and the associated aggravated robberies are set at $75,000, which is highly excessive. Before we go to the facts of those aggravated robberies, we're going to be asking for a bond of $10,000 each on the aggravated robberies, given the circumstance.
All right. And what bond would you be asking for on the aggravated assault?
It would be ideal to reinstate her bond at $15,000, but we will go with whatever the court wishes to do.
All right. And State, are you prepared to proceed?
Yes, ma'am, we're ready.
Any witnesses? State or defense?
None, Your Honor. I do have, I'd like to give the court a packet. I can do it one or two ways, either, and I've shown this to Mr. Wilkins, series of pictures, and I've marked it as defense exhibit number 1. I can have my client identify it, or as an officer of the court, I can identify what those pictures are.
All right. Any objections to defense exhibit number 1?
No objection, Your Honor.
All right. Then the court will set exception to evidence defendants exhibit number 1.
If I may, Your Honor, what the court is looking at in defense exhibit number 1 is the first photos are of the 3 complainants in the case. The very first picture is Christopher Cooper, who is the biological son of my client. He was not raised by Ms. Cerna, but they are biological. And the other 2 are friends of Mr. Cooper. Additionally, you're also seeing social media posts of the various complainants in their various photos with weapons, with smoking blunts, with putting up wads of cash with those weapons as well. And lastly, there are injuries to Ms. Cerna's arm that occurred during that robbery. And we do want to address that when we get to that point. But that very last photo is a kind of fresh photo, and it's kind of hard to see in the black and white versus color, but she was cut by one of the complainants.
The court sees defense exhibit 1 with the alleged complainant listed. The court sees what appears to be the complainants holding AK-47s and Glocks. And then the next photo appears to be the complainant, who is the defendant's son, holding cash, wearing pants that are 30 sizes too big, that are sagging. Then the next photo appears to be 2 complainants with someone with a gun, but there is no face to the person holding the gun, pointing the gun at them as they smoke blunts and photograph the person pointing the gun at them. Then the next photo appears to be someone holding a gun. And I believe that's the complainant that is listed on page 3 of defendant's exhibit number 1. And then the court sees photographs with no face. So I don't know, I'm taking you at your word saying this is your complainant, that there's no face, but it appears there's no talking by you unless you're under oath. But I do see photographs that appear to match the mark that's on your client's arm. But again, her face is not pictured in defense exhibit number 1.
As an officer of the court, I will say that I've talked to my client. She has identified the 3 complainants, that being Jonathan, Joseph, and Christopher, being the ones in the photos. And I'll also point out to the court that these photos taken from social media were, so my client got those while she was out on bond, and was able to forward that to me before she was taken into custody on these new aggravated robbery charges.
Okay.
Additionally, Judge, if you look at the facts and circumstances of the case, I know we're not here to litigate the entire aggravated robberies, but there's an allegation that Ms. Cerna and her husband pulled out guns after inviting her biological son and his friends over to La Quinta to see a just under 2-year-old stepsister that was born that Mr. Christopher Cooper has never met before. Suddenly a robbery occurs allegedly with firearms by Ms. Cerna and her husband allegedly. However, if you look at the facts and circumstances again, La Quinta management throws out everybody out of the hotel. There's an argument going out in the parking lot when supposedly my client and her husband have firearms, yet somehow these complainants are hanging around in the parking lot with them when they've just been threatened with firearms. Doesn't make a lot of sense. Additionally, Ms. Cerna does have that injury to her arm. She was cut. Once again, if she had a firearm, she wouldn't be in the position to be cut by Jonathan Vidales, who is in fact, all of these are, well, actually, Jonathan and Joseph are juveniles. Mr. Cooper is, I believe, 18 years of age at the time of this event in October of last year. But the circumstances are very suspect, Judge. So without going in, and obviously this court is not going to make a judgment on the veracity if he's guilty or not guilty of those specific aggravated robbery charges. But given the circumstances for setting a bond, we believe that because of the nature of the weirdness, essentially, of this allegation, we're asking that bonds be set $10,000 on the aggravated robberies so they can be litigated down the road. And we'll see further in the future if, and this case is unindicted. These 3 charges have been unindicted for the past roughly 60 to 90 days. We will see if the district attorney's office will even go forward. I mean, obviously, Mr. Wilkins might know more about if they even have complainants that are going to be continuing to complain in the future. So based on that, Your Honor, and the circumstances, we're asking that the bond be set on the aggravated assault and a much lowered bond be set on the aggravated robberies. Obviously, if the court wants to do GPS, that is more than fine. We might ask the court to reduce or waive GPS fees, but if the court wishes to do that, we need more. Ms. Cerna will certainly comply with all GPS conditions.
All right, State.
Yes, Your Honor. We are asking that you double the bond on the aggravated assault weapon. 2,000. We're asking that on the aggravated robberies, and keep the bonds at 75,000 each. We're also asking that you has these conditions of bond, the special conditions. We're asking keep the GPS with full house arrest in place, no contact with the claimed witnesses in the aggravated robberies. Jonathan Vidales, Joseph Berrientos, and Christopher Cooper. Prohibition on possessing firearms. And Judge, I previously sent it to the court of appeals, but I didn't want to figures here.
If you have marked those as States Exhibits 1, 2, and 3, and defense, have you had a chance to review those documents?
We have, Your Honor, no objection.
All right, then States Exhibits 1, 2, and 3 are admitted, and of course, defendant's exhibit number 1 is admitted, and you can tender those to the court reporter. I've reviewed those.
So
And I'm sorry, just so the record can be clear, those were reviewed before they were offered into evidence, and both the defense and the state requested that the court review those before they were offered into evidence.
Objection.
In the police report, these are very serious allegations. We're asking that the bond be set at this high number in order to protect the community. The code says that you can set reasonable conditions of bond. We think under the facts alleged in this police report, these are reasonable conditions. This amount as well as full house arrest GPS. If we were inclined to grant a lower amount of bond, we would have still have the other conditions. I reviewed those pictures, and I think some of the questions that the report had too. You know, this is a picture. I don't really know what this is. This could be an airsoft gun. This could be a real gun. These guys could be engaging blunted, or this could be tobacco. A couple of these guys are juveniles, so they have guns in these pictures that are undated. I think we don't know when that is. I don't think any allegation that at the time of the offense, October 27th of 2023, that any of the complaining witnesses had guns at the time. That's not any. So, Your Honor, in order to protect the community, we are asking for those bond amounts as well as the full house arrest.
And lastly, Judge, if I may, what I forgot to mention was nowhere in that police report does it say that anyone beyond the complainant said that Ms. Cerna and her husband had firearms. The hotel manager was told she had a firearm but never saw it. So I want to be real specific about that.
And just briefly, I mean, when I was reading the police report, if you're in a hotel room, I don't typically invite the manager into the hotel room. I don't know how we would see if there are guns or not.
This is as everyone was exiting, all the parties.
Okay. So is there anything else from either side?
Maybe more business.
All right. So I'm going to keep the previous conditions of full GPS. I'll ask that the fees be waived. For the aggravated assault with a deadly weapon, I'm going to set the bond at $25,000. And that is cause number 2023 CR 5815. And CM number 114217, the court will reduce the bond to $60,000. And that's based upon what the court has reviewed in the police report. And cause number CM 114220, the court will reduce the bond to $60,000. And in cause number CM 114222, the court will reduce the bond to $60,000. And there's to be no contact with, is your husband Ruben Cerna? Yes, ma'am. There's to be no contact with Ruben Cerna. All right, is there anything else?
Nothing, Your Honor.
All right, Ms. Ferguson, we need a jury trial date, a quick date on this case. State, how long do you expect this trial to last?
3 days, sir.
All right. So that means it'll probably be 2 days. The earliest date you have. All right, we'll come back for jury trial on February 6th. If you're still in custody, you will be brought over in trial dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something else, you'll need to do a clothing exchange. Mr. DeLeon, if there's an issue with the clothing exchange, let the court know.
Yes, Your Honor. We thank the court.
All right, and do you know if your client will be going, if she were found guilty, do you know if she'll be going to the court for punishment or the jury?
We haven't discussed that yet, Your Honor, but probably the court.
All right. Eric Lopez. All right. Thank you. Yes.
Good morning.
Good morning. Norma, on this case, when do you want to bring it back for jury trial? Daniel, this is yours. Yes.
The court's aware, in speaking to one of the detectives involved in the case, she is currently pregnant. She did say, I think she was due in March. So if there's any time in between now and March, we can check this on.
All right, Norma, we'll need some time before March. Yes.
And then my understanding is that she's going on maternity leave for 6 to 8 weeks.
All right, when will that be?
And I believe that's going to be starting in March. It really is kind of a rolling date because I think
Yes.
because it just coincides with.
All right, so we're going to come back on February 6th for jury trial.
Thank you, Judge.
Thank you, Judge.
All right, you're welcome. So you don't need to be here on the 16th.
Okay, I appreciate it. Thank you.
Pete Garcia. Oh, do you need a break? All right, just give us 1 second. I'm sorry, just a brief break. I'm sorry. It is CM 114217, CM 114220, and CM 114222. And then the other cause number is 2023 CR 5815. Sure. Andrew Orozco. Andrew Orozco.
Your Honor.
All right, come forward, please. So where are we on this case?
So this case, Your Honor, was originally assigned to Mitchell Russell.
Yes.
So the court, Norma's going to appoint me on this case because he has pending aggravated assault with deadly weapon case amongst other cases. I conferred with Daniel on this matter. The state wants to reset so we can move forward on the higher offense level cases.
All right, so. Okay. All right, so, can you give me a month reset? Is that enough time for everyone?
Yes, I'll it here.
Okay, all right. All right, we'll be back.
Defense counsel will be out. Remember, I don't come back until we try that case with Kathy.
Yes.
I know the 8th, we'll be back the 18th, and we start the trial, I think, on the 20th.
Which case are you, 'cause are you on Eric Lopez with her now?
Angel.
Angel, okay.
Well, that starts that Tuesday.
So let's put it on the same date as that. Yes, that works. All right, February 20th. All right, is there anything else? No. All right, thank you.
Thank you.
You're welcome. John Anthony Ramirez. Who's the attorney for John Anthony Ramirez? Dinah, are you ready? Are y'all ready to proceed on the motion to revoke?
Yes, Your Honor.
Court is calling 2000. Please do not talk behind the court reporter. We're on the record. If y'all will remove it to this end. Court is calling 2016 CR 6340, State of Texas versus John Anthony Ramirez. Michael, can y'all move it to that end? Right. Court is calling 2016 CR 6340, State of Texas versus John Anthony Ramirez. Can I have parties announced for the record for the state? Defense.
Renee Munoz on behalf of John Ramirez.
Are you Mr. Ramirez? Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same John Anthony Ramirez who was placed on deferred adjudication in 2016 CR 6340 for the offense of aggravated assault with a deadly weapon on April 10, 2017 for a period of 5 years and extended for a total of 3 years? Third state.
Violated condition number 5 in Barron County, Texas. The defendant, John Anthony Ramirez, then and there failed to report to the supervision officer as directed for the months of July and August 2023 in violation of condition.
How do you plead to that? True or not true?
True. Your Honor, it is all that.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there a proposed agreement?
Yes, Your Honor, we have already proposed probation. It's for the defendant to report twice a month for 3 months virtually or in person. Monthly waives for the defendant to continue treatment with the Center for Healthcare Services and to comply with his medications. And that would also amend food ask.
All right, probation.
You did confirm that. That is the agreement.
All right, so here's the court's issue. He's been here before me previously for not reporting. So how is this going to solve the issue? And I'm taking in consideration his mental health issues. So how is this solving the issue?
Yes, Your Honor. At first glance, I can see the court's concern. I spoke with my client and he did state that he is currently receiving services with the Center for Healthcare Services, Judge, who has been prescribing to them. I have receipts of a document from Jennifer Munoz, his case manager. I can tender it to the court. Yes, please. Doesn't have an issue with that. He's been under their care for the last 18 months, Your Honor.
All right, you don't need to whisper in the box. If you can't whisper in the box, then you can't talk in the box.
He's been reporting with them for the last 18 months and has been consistent with his appointments with them, Judge. He started off with pills, oral medications, but now he's on the injection. He takes once a month and he's now currently stabilized. I believe the issue was a little miscommunication with probation. I know that probation wanted him to try to get help at Palo Alto. My client states that he went to Palo Alto to get help, and they said, we can't follow up on your care. You're already seeing the Center for Healthcare Services. My client has stated that he can't afford the UAs, and the probation officer essentially said, figure it out. And we are figuring out, Judge. His family's going to help contribute to that UA, so that's not going to be an issue. And I told clients that, no excuses in terms of not missing probation. If he needs to take the bus, he needs to take the earliest bus possible. So even if he misses a bus, he's on time. If he's there and they're saying they can't meet with him, to document that, to take a picture, he was there, email me, email the court. Hey, I'm here. The probation officer is not able to meet with me at this time. He's wanting to reschedule, but he has been making his appointments regularly with Center, Judge, and he has been doing well with them. So it seems like he has a lot going on, but I'm telling him that he needs to make good on his requirements to the court and probation, that they need to meet with him, they need to see him. But his sister did furnish me that document from Center for Healthcare that he is receiving treatment, Judge, and I think he does seem stabilized to me. He does seem like he's wanting the treatment, and he's already set up with the center. So we're respectfully asking the court for him to allow that. I did talk with him about the proposition before the court with meeting with probation. He has no issue going there down in person. He's going to take the bus. He's going to have family members take them. He's going to establish a better communication with the probation officer. I think has a year left after all the extensions, when it's all said and done, to expire in 2025 in April, Judge. So I'm encouraging him to give this last push. He's been on probation for quite a while. I think this case originated in 2016. So he has not picked up any new number ones. He has not demonstrated any violent behavior. He's demonstrated that he does need mental health services, and he is, he is taking measures to help himself in that regard, Judge. So we're asking respectfully.
All right. In probation, I'm assuming that you all will have access to his compliance with Center for Healthcare Services.
Yeah, we'll ask for a release of information.
Oh, you have the release?
Yes, Judge, I filled
Thank
out
you.
just in case we get the records.
All right. All right. So I don't think it would be appropriate for him to have to report more often than he's currently reporting, because it seems to me the issue is his mental health. So if there's no objections, what I'll do is I'll deny the motion, alternate conditions. He needs to continue with mental health care with Center for Healthcare Services. He's you to make sure that you report monthly. You understand? Mm-hmm. And you are to provide a release so that the probation will be able to see how your treatment is going for Center for Healthcare Services. The court will note for the record that that release has been signed. Is that correct, counsel?
Yes, Your Honor. We have executed that.
All right. Is there anything else?
Nothing further, Judge. We greatly appreciate the time.
All right, Mr. Ramirez, we're off the record. If there is an issue, you can always come to court and let the court know what the issue is, and we'll make sure that you're on track. Okay, you understand?
Yes, ma'am. I understand.
All right, good luck to you.
Thank you, ma'am, very much, ma'am.
All right, you're welcome. Philip Diller.
Morning, Your Honor.
Good morning.
I just needed to approach the court. I have just been conferring with the Assistant District Attorney. I had previously spoken this morning to Anna.
Mm-hmm.
We are set on the 16th for a jury trial.
Yes.
And we were set earlier in January, and the court set it for the 16th.
Yes.
Well, back in October, I had a felony case in Comal County that was set for trial on the exact same day, January 16th.
Mm-hmm.
But they make you come the Tuesday before, which was a couple days ago.
Yes.
And then I received an email from them that I have to be there on Tuesday by 9:45, ready to go to trial on that case. And so I had that setting prior, that case was set prior to when the setting was changed to the 16th. So I'm just looking for court's guidance. Do I go there? Do I tell them I can't go there?
Well, is that case in Comal County a felony?
Yes, it's a felony drug case.
All right. And how long has that case been set?
It's,
I mean, how old is that case? Because we've been trying to get a jury trial done on this.
you're right, Judge. You're right. I believe that the case, certainly the offense date for the 187th case is many, many years before this guy's case.
So what we will do is this will be set in this court on January 16th. And if you need us to, we'll call Comal County and let them know that you're here. So we will put you under the umbrella of the 187th and it will be fine.
Okay.
Yeah.
That's fair.
Sure. All right.
Thank you, Your Honor.
You're welcome.
No, have a great day.
You too. All right. Are we ready on Pete Garcia? Oh, it's coming back on the 16th. It's still scheduled for trial, but we'll probably need to call Comal County on the 16th and let them know he's in trial here.
Right in the middle.
Okay, good morning. All right, I believe this is family violence.
Over here now, right?
Yes. And Mr. DeLeon, you need to go to another court for your jury trial?
Eventually, but I have another matter.
All right, whenever you're ready, let us know. Court is calling 2022 CR 6930, State of Texas versus Pete Garcia. Can I have parties announced for the record for the state?
That's done for the state, Your Honor.
Defense?
Daniel De La Garza for the defendant.
And are you Mr. Garcia? You entered a plea on December 5th to count 1 of guilty. According to the plea bargaining agreement, punishment is to be assessed at a cap of 8 years in the prison. There's a $1,500 fine. The state is opposing your application. They're taking in consideration 2023 CR 8852 and 2023 CR 8851. And there is to be restitution, if any, to the complainants in each of those cause numbers. No contact with the complainant and Chapter 62 compliance. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections?
No, Your Honor. No, Your Honor.
All right, are there any witnesses?
No, Your Honor. Not just the state, Your Honor.
All right, state you are opposed.
Yes, Your Honor.
You may proceed.
Yes, Your Honor. Your Honor, the state would just like to begin when looking at the PSI. This individual had cases out of, I believe it's Manatee County, Florida, put on probation for a drug offense, 28 grams to 150 kilograms.
Just 1 second, I'm sorry. Probation, on this case, I don't have the PSI report in the email. That's okay. Thank you. Just give me 2 minutes. Okay, thanks. All right, you may proceed.
Thank you, Your Honor. This individual was placed on probation on 2 different occasions at Manatee County, Florida, once in 2006 for 28 grams to 150 kilograms of cocaine charge. Also 2007 at Manatee County, Florida for use of investment proceeds from racketeering. 2 separate instances of probation outside of the state of Texas. Within the state, within Barrett County, there was this individual was transferred to TC and sentenced in 2019 with tampering of a government record. Also 2019, unauthorized use of a motor-propelled vehicle. Again, sentenced, transferred to TC on both of those. The victim in the credit card abuse case said in the PSI, quote, "I'm not okay with probation
I want him to do time. I'm sure he will do it to someone else. I don't think probation is the solution. He will do it again. He will do this to someone else. The victim in the fraudulent use of possession of an ID case said, quote, I'm absolutely not okay with him applying for probation. I just want him to go to jail forever. He's an egregious violator of the law. So that's with respect to those two cases, Your Honor, that we're taking into consideration. In the instant case, the indecency with a child by contact, as mentioned in the STIPs, a short 2 or 3 sentences from the report. Juvenile Jalissa Leone told her mother that Pete Garcia fondled her breast and nipples on 10 separate occasions. She stated the incidents occurred when she was 11 years old, while Pete Garcia resided at the residence. Juvenile Jalissa Leone did tell one of the interviewers that it never went further than that, but that Pete Garcia told her, quote, don't tell your mother when the incidents occurred. Your Honor, in the PSI, this would be victim number 3, Your Honor, again, with respect to the indecency. When questioned, that victim said, just take one quick moment, Your Honor. And victim Jalissa Leone said, quote, I want him to take some accountability. I don't want probation for him. I suffer from really bad PTSD now because of this incident. I get scared to go to sleep because I have really bad dreams. I get scared to be alone with certain people because I never know what could happen. And Your Honor, I think the word there that of course sticks out to me from the victim in our case, the indecency, the incident case, I should say, is that accountability. And to kind of in summation, if you will, Your Honor, the final point is when the defendant, speaking to the accountability, the defendant was questioned why he feels he should be granted probation. He told them, quote, I need to continue with the life I was living. So the life he was living, Your Honor, caused all of this harm in Bear County alone, and of course criminal offenses stretching back over 15 years. When asked, the defendant said, quote, I don't want to talk about this right now. I wasn't consuming alcohol or drugs on the date of offense. The lack of accountability and wanting to go back to the life he lived, and if somehow not being under the influence of drugs makes any of this conduct okay, Your Honor. They respectfully believes that this individual is not qualified or suited, again, under the eyes of the state for probation.
All right, defense.
Just briefly, Your Honor, he definitely does take accountability. He does take responsibility for what happened, and he'll be happy to tell you that if you'd like to ask him. But the point is that
want to testify?
you want to tell the judge that you're sorry.
Here's the thing, before you begin, if you want to testify, you're going to be placed under oath and the state will have a chance to cross-examine. So do you wish to testify? All right, can you raise your right hand? Excuse me, person in the black jacket. The person in the black jacket, they need to be excused from the courtroom. They're talking to someone in the box. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your name. I'm sorry, lower your hand and state your name for the record. All right, Mr. Garcia, just one moment. Mr. De Leon, do you let me know if you need to go for your jury trial?
We want to go that bad, but I appreciate it.
All right, just let me know. All right, we may continue. All right, defense.
Yes, Your Honor. Well, hold on. I gotta ask you some questions, right? So first off, you know that you pleaded guilty to the indecency case, right? Yes. And then you've taken responsibility also for the credit card theft and the fraud cases, right? For lack of a better term. 100%. I just want to put back the restitution.
I'm sorry, you need to speak up.
I just want to give a chance to pay back the restitution, Your Honor. The last 3 years of my life, for once, I have a good paying job. I just signed a 30-year mortgage 8 months ago. My life is finally on track. And, this incident happened in 2016, 2017. 7 years later, it came up. And I do take full responsibility of all my actions. I do.
So let me ask you, when you say all your actions, are you talking about the case that you have pleaded guilty to, the sex offense, for lack of a better term?
Yes.
And you're talking about the case the judge will take into consideration. You take responsibility for all that, right?
Yes.
Now, let me ask you a question. Now, tell the judge when the prosecutor says go back to the lifestyle or whatever, what did you mean by that?
What I meant was, in the last 3 years, Your Honor, my life has been me and my spouse. I have been on track. I go out for a month. I come home for a week. I've been doing that for 3 years. I finally, like I said, Your Honor, the life is what I meant was me getting my life back on track, finally living a normal life.
Now, let me ask you, who's your spouse?
Jasmine, my Honor, is
she here today?
Yes.
I'm going to point out for Your Honor, sure, right there in the Under Armour shirt, waving her hand. Okay. And then if you were granted probation, is that where you would go back to live?
Yes.
Okay, and let me ask you, are there minor children in that house?
None.
And you have your own children, right?
Yes, they're grown.
What do you mean by grown? How old's the youngest?
21.
Okay. And do they have children?
Yes, my son does.
Okay, now if the court will order you to have no contact with minor children, is that something that you'll abide by, first off?
Yes.
Then second of all, you're gonna have all kinds of conditions that you need to abide by, such as the sex offender counseling, maintaining employment, reporting to probation. Are you gonna do all that stuff?
100% complete, yes.
And then where are you gonna go back to work?
At Halliburton.
What's that?
It's a oil and gas company.
What do you do there?
I'm a CDL driver. I deliver frac sands.
And if your CDL license is suspended or you lose it, where would you go work at that point? Let's just say.
It's a family member that works there. I would be working as a laborer.
And then now the judge is going to give you, can give you up to 8 years in prison or deferred adjudication for up to 10 years. What are you asking to happen?
I'm asking for the 10 years and just to give me that chance to pay back this restitution. And I just, for one time, have a normal life. I accept everything that I did. I just want to move forward. I finally have it. I feel like everything's going to get taken away, but I do accept full responsibility, man. I just want that chance to pay back, give them what they're asking for, the restitution, and just move on in my life.
That's what it's here.
Right. State.
Just a couple of questions, Your Honor. Are you aware that when the complainant first outcried, the reason the outcry happened when it did is because she was having frequent and violent sexual dreams? Were you aware of that?
No, I have had no contact with them in 7 or 8 years.
And if she hadn't had such violent dreams, there's reason to believe that she wouldn't have outcried. If she wouldn't have, would you have done something to take accountability for your actions, confess or do other actions or take other actions to take responsibility for the double-digit number of times that there was the touching of the breast with your hands?
I don't understand.
And I apologize, to put it simply, if she had never outcried, would you have found a way to take accountability for your actions?
If there was something said, then of course, 100%. I do take accountability for my actions. And like I said, it's been almost 8 years. I have not heard anything until recently. So, of course, yes, I 100%.
All right. So I have a question for both parties with regards to the restitution amounts. One complainant says the restitution amount is 0. Mejia is saying their restitution amount is $15,000, but that $15,000, they're saying that's the money they borrowed, but that the bank reimbursed them.
That was my understanding.
So it appears that the money has been reimbursed. So I understand that there is cost because they borrowed $15,000, but then the bank reimbursed $15,000. Now I can understand maybe he's responsible for the interest of the $15,000, but the court doesn't have the interest amount for that. But, and if I'm wrong in my legal conclusion to this, I don't think he's responsible for the entirety of the $15,000 if the bank, it appears from what I'm reading, the bank has given him back the $15,000.
Yes, Your Honor. I would agree with that.
So I don't have a restitution amount for that.
Yes, Your Honor. I believe that is correct. I see exactly what the court is saying, and I don't believe there would be any restitution remedy available.
Okay. All right. This is what the court is going to do. The court will deny your application. Does anybody want to speak to the cap? The court is going to find you guilty. Anyone want to speak to the cap of 8 years?
Well, just Your Honor, we would ask that he, based upon the fact that he has taken responsibility and that he has, amends for what he's done, that we ask that you hit somewhere below the cap. And I would leave that up to the court's wise judgment, but I would ask somewhere below the 8 years.
All right. All right, Mr. Garcia, I want to let you know that I read the entirety of the PSI report. I read the police report. And I've seen the ages of the complainant, the age of the complainant in this case. That's an issue for the court. You understand? All right, court will find you guilty, sentence you to a $1,500 fine, time and money to run concurrent, taking consideration 2023 CR 8852, 2023 CR 8851. There's to be Chapter 62 registration, no contact with the complainant, and either of the cause numbers. The court will sentence you to 8 years in the prison, give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right. So off the record, I understand that people have regrets about things that they've done in their past. And sometimes we hope that our past won't come back and bite us, right? Because you moved on with your life. I understand it as you're working. I know that that job you had was a great job. I know you have the 30-year mortgage. But when offenses and crimes happen, you have to answer for those. And at some point, what we've done catches up with us. You understand?
Yes, ma'am.
All right. Good luck to you, okay?
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
And I'll need those dismissals. Who's here on Stephen Estrada?
I hate to do this, I'll do this, but I'm just trying to do another case. We can put people in behind.
Sure.
Me not click on me, but he says.
Okay. John Ray Perez.
Ready at home.
We're not quite ready yet. Sorry. Still looking at it.
All right. John Thomas Lyles.
Mr. Scott, I'm ready after.
Thank you.
Oh, Mr. Miles is a peer judge, but the court will call his. It's suggested that we reach out to the health coordinator. I have, but I haven't had any contact since we were here for the.
All right. Is he on,
I don't
is he on a surety bond or a PR bond?
surety bond, I believe.
It's John Lyles. Do you have any contact information for him?
He wouldn't give me anything other than friend of his mother's. He is homeless.
All right. Court is calling 2023 CR 9074, State of Texas versus John Thomas Lyles. Can I have parties approach and announce for the record for the state?
Hank Wilkins will say to us.
Defense?
Tony Adonis on behalf of Mr. Knox.
All right, this hearing was scheduled at at 9 a.m. It is now 10:46 a.m. The defendant has not appeared. Counsel, do you have any idea where your client is?
I did not judge. I know he is homeless, but he did sign the reset notice to the waiver.
All right, and this is a commercial bond, State?
Your Honor, we're asking for a bond forfeiture this morning.
All right, that'll be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider. You may want to try calling the bondsman, and maybe they have contact information for him.
I'll do that. Thank you.
All right. Miguel Ugui.
Michael Uguga.
Ah, Michael, thank you. All right, today is the plea deadline date.
We received the plea offer today that may or may not change depending on the prosecutors in contact with the complainants this week. We're waiting for a time to speak to the complainant, made an offer, but it's one that still, we spoke with the complainant briefly, was recognized it, and they stated this is what I'm offering is within the state of want. I'm just going to talk to them to see if we can do that.
All right, Ms. Ferguson, on this case, if you'll call it back for January 18th.
Thank you.
All right, once you sign the reset form, you're excused.
There'll be a plea deadline.
Yes.
Thank you.
And counsel, your client was late.
He stopped me as I walked in and told me that he was outside on the bench. He didn't notice the people coming in. But he does come inside.
Okay. All right, thank you. Are y'all ready on John Pettis or still conferring?
Yeah,
All right. Stephen Estrada.
Judge, Mr. Estrada was kind enough to let me know that somehow they said he was exposed to COVID, so I got him a mask. That's why he's wearing a mask. I don't know if it's true or not, but anyway, that's why.
All right, so we were scheduled for jury trial. Where are we?
Judge, you made an offer. I've thoroughly discussed the offer with Mr. Estrada. I've explained the consequences of not taking the offer and that the court will not take any agreement. It will just be an open plea in court. I passed on the offer, and I'll be real blunt. I've given him hopes that if he gets a lot higher, it's on him, not me, and I'm not going to feel guilty. He said that he wants a trial, so I'm passing it on to the court to get it.
All right, Ms. Ferguson, I need a jury trial date for this as criminal trial division. I need it as early as possible. All right, you're coming back for jury trial on February 6th. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you'll need to plead open to the court. You'll be brought over dressed for trial in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to speak to your attorney and do a clothing exchange. If there's an issue with the clothing exchange, let the court know.
Judge, I appreciate it. Thank you for letting me come in today rather than Tuesday. And I'm still going to bet with you on the fact that there's going to cancel court.
You think they're going to cancel the court on that date?
It's not that I would, but you notice certain things like the sun rising in the east and setting in the west. After a while, you notice patterns.
Okay.
Your Honor, may I say something more?
Sure.
I just want to see if I'll be able to dismissal counsel. I've been incarcerated going on 3 years, and I'm still to see and get the discovery pack on any racing.
Oh, you want to see the evidence? State. Can we put him in the box? Counsel, can you let him see the evidence? And if you want another attorney for your jury trial, they need to be ready for trial on February 6th. You understand?
No.
And Judge, just be clear, I don't care one way or another, but if you are going to put someone else on the case, please let me know so I won't.
Oh, no, he's going to have if he wants another attorney, you'll have to hire that attorney. And that attorney needs to be excused. That attorney needs to be ready for jury trial on February 6th. And state, if you'll let him, and counsel, if you'll stay so he can see the state's law. Arturo Lopez.
Yeah, we have 4 minutes here. We'll be changed something.
Okay.
We're ready on our.
All right. Thank you. John Ray Pettis. Oh, and state. If you all want to speak with Mr. Contrail about his client who was here the other day.
Oh. There's a warrant for his arrest.
Yes.
He didn't come back yesterday. Tell us what he did.
Oh, no, I think the person he was with, they came back and stood in the hallway. So he may make an appearance. Court is calling 2022 CR 7826A, State of Texas versus John Ray Perez. Could I have parties announced for the record for the state? Defense?
Michael De Leon for Mr. Pettis.
And are you Mr. Perez? All right, everyone, we're on the record, so I'm going to ask that you please whisper. If you cannot whisper, then do not talk while we're on the record. All right, did you review a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision? And First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision. With your attorney, did you understand it? All right, you're going to have to make sure you speak up.
Yes, sir.
All right. Are you the same John Ray Perez who was placed on deferred adjudication in 2022 CR 7826A for the offense of burglary of a building with intent to commit theft on January 10th, 2023 for a term of 2 years? Is that you?
Yes, sir.
State?
Violated condition number 1 on or about the 8th day of November 2023 in Bexar County, Texas. Defendant John Ray Perez committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True. Your Honor, we waived the other violations alleged in the motion.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, sir.
Court will find violation of condition number 1 true. Is there a proposed agreement?
That you deny the motion and continue the defendant on community supervision. We would like to alter and amend the conditions for SATIF. That's going to run concurrent with the new number 1, concurrent with 24-2 case 72109.
All right. And with regards to the county court cause number, is that case still open?
It is, Your Honor, because it's enhanceable. Would like the defendant's going to go down and plead directly after the sentence.
All right. And who's the attorney on that case that's in this court?
Feel like it's me now. So
You're just coming forward solving problems.
I'll take care of it, Judge.
All right. And Mr. Perez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right. You can lower your hand, state your name for the record.
John Ray Perez,
All right. So what's your drug issue?
Maryland.
All right. We're doing more than SATA for marijuana, are we not? All right. Mr. Perez said the only problem he has is marijuana and nothing else.
Your Honor, we don't have any drug tests to confirm confirming that there was a violation to his outpatient program.
Have you done anything on probation other than not report, pick up a new case, and not doing your drug testing?
I went to my classes.
What classes?
The drug classes.
Obviously, they're not working, right?
Right.
So you're just telling me you'd rather go to 2 years to the state jail facility and then come out and use your marijuana?
Yeah.
Then why are you using marijuana? Because I know people think marijuana is not a big deal, but I tell you what, in Texas it is, and you can't smoke marijuana or use marijuana in brownies or cookies or whatever while you're on probation. You can't even drink alcohol while you're on probation in Texas. So would you like, if you want, I will grant this motion and I will send you to the state jail facility. You will be done. And if you choose to smoke marijuana, that's on you. If you get caught smoking marijuana, you're going to get arrested. That's on you. So if you want treatment, I will give you treatment. But if this is just, I'm doing my best right now to stay out of custody as quickly as possible, but you're still going to use, then now's your time to make the call because you know yourself better than your attorney does. And is there a family member here for you?
No, no.
All right. So you know yourself better than I do and the attorneys do. So if you want, I will deny the motion of alternate amend conditions and send you to SATA. Or I will revoke you and I will revoke you and sentence you to 180 days.
Your Honor, if I may,
Yes.
Mr. Pettis and I had a conversation. I think he wants to avoid having a felony conviction on his record. He doesn't have any other felony convictions before. So that was the reason why when probation recommended SATA, we're like, okay, we'll do it.
Okay.
I had the same reaction when I heard marijuana as well. I'm like, but that's different because unless you want to do 180 days and just have a conviction on your record, and do 106 months in state jail facility.
180 days?
Yeah.
It's day for day.
Day for day. But it's a conviction on it.
And let me just tell you what's going to end up happening. When I do that, if that's what you want, when you are released, you're going to immediately go back to doing what you've previously been doing. And one or two things going to happen. Either you're going to pick up another evading case or something else is going to happen. And you're going to be right back in somebody's felony court or misdemeanor court or whatever. And your problems will still be there because when you stop running, your problem is still there.
I'd rather take the.
Okay. And is there something you wish to say?
Oh, yes, Your Honor. I believe after speaking with probation, his probation will need to be extended 6 months to accommodate the SATA.
Okay. All right, it will be extended. However, if you complete everything, then of course, you can ask for early termination. You understand?
Yes, ma'am.
All right, so this is what I'm gonna do. I'm gonna extend you for 2 years. Alternate amend conditions to do a referral to felony drug court. And if felony drug court doesn't accept him, then it will be SATA. Felony drug court will be able to probably interview. Next week is a short week, but they may be able to get to you next week. And you need to be honest with them about your issues.
Yes, ma'am.
Right. Probation, we'll do felony drug court first.
Yes, right. And then SATA.
Yes, and that's to be while in custody. All right, is there anything else you need from the court to be successful?
Yeah.
All right, we can go off the record. How old are you?
I'm 31.
All right, do you want to be the 31-year-old at the prison where somebody asks you why you're here and you say it's for marijuana? All right, do better. All right, good luck to you.
Hey, Judge,
Thank you.
was maybe excused?
Yes. Who's here on Alberto Camacho? All right. Griselda Rosales?
Judge and President for is here. Do you want her to come forward?
Yes.
Mr. Zell, please come forward. Judge, I think I'm agent of illness. She's feeling a little under the weather, so she's going to stand back a little.
Sure. All right, today is the plea deadline date?
Okay.
Yes. So is she accepting the offer or no?
No, Your Honor.
All right, Ms. Ferguson, we need a jury trial date on this and quick turnaround.
Could I ask for the same date I'm coming back on the other one, February 6th?
Sure. Norma, can you put this on February 6th for jury trial? All right, once you sign the reset form, you're excused. Your plea deadline date has expired. The court will not accept any plea bargaining agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand? All right, thank you.
There's another case, Mr. Estrada. He really doesn't like me, which is why I did a discovery, told me to stop. I'm just telling you because I was present. I'm going to file motions to withdraw to protect myself.
Oh, I understand.
Okay.
Where is he? If you can come forward, sir.
And Robert Maurer, through his son, I asked him to take the case and he said no, but my son.
Nobody can do as good as Eddie Judge. He's the best judge I've ever seen. I've ever seen.
His vision is
I would
also,
want him as my lawyer if I were.
he has cataracts, so what do you want?
All right, so I want to let you know something. You came before the court and you said that you had not seen the state's file. I'm being told that you no longer want to see the state's file. So let me just tell you what's going to end up happening. You're going to go to trial whether you've seen the evidence or not. That's completely up to you. The court gave you the opportunity to sit in court and look at the state's file. You're choosing not to. So you're going to come back for trial on that day. Do you understand?
Not that I don't want to see it, Your Honor. It's just I've been incarcerated going on 3 years, and I just feel like I'm being rushed to something that.
Oh, no, you said you've been incarcerated for 3 years. So how are you being rushed?
Exactly.
You're going to jury trial on February 6th.
I'm barely hearing anything about it just within these past couple months now.
He was in another county.
I've been in another county, so this whole time I've been incarcerated, I haven't heard anything out of
So let me ask you this. I want you to internalize what I'm saying. You were in custody in another county for what reason?
For ag robbery, allegedly.
So there you go. So this case is going to trial on February 6th. If you would like, I've given you the opportunity to sit in the box and read what the state has. What the state has in their file is what they have. The only,
I understand that, Your Honor.
here's the thing, the only thing about it, what's in the state's file are the names and police reports. Those people are not going to come in and let you talk to them right now because that's not what it is.
I understand what you're
But you
saying.
can look at the file. So you're coming back for jury trial on February 6th.
That's fine, yes, ma'am.
All right, thank you.
Thank you.
All right, are you ready on Arturo Lopez, Alberto Camacho, Richard Alvarez?
We go through two Macho's attorneys and another court judge.
All right. So they are not ready. All right. Family violence.
Yes, Your Honor.
On Mr. Richard Alvarez, defense counsel is ill. So I'm going to grant their motion for continuance. If there's no objection, they have a doctor's note.
There is no objection.
All right, Ms. Ferguson, when do you want to recall Richard Alvarez? All right, so we'll do it on the 22nd then.
Thank you, Your Honor.
Thank you. All right. Your attorney is out ill. So we'll bring you back on the 22nd. All right, just wait. And once you sign the reset form, you're excused.
Your Honor, may I quickly approach on the
Yes. They left you alone. But they brought in breakfast tacos. That's
All right, that's all fair.
sure.
You're not panicking, thinking Alabama might steal away your precious Brian Kelly?
No, I'm not.
I'm sorry. I didn't lay on the sarcasm enough.
We're doing prayers. Sure. Yes, we'll take.
They had a vigil by the Nick Saban statue, and they just kept chanting, "Anyone but Dabo, anyone but Dabo."
Alexander Torres.
Good morning, Judge.
Good morning.
A couple of things. Alexander Torres, they didn't bring him because he's got lice. But in addition to that, I filed a competency eval.
Okay.
And it was ordered back in November. So we're waiting for the results.
The report's ready, Judge. We're just waiting for them to transfer it.
All right. And how long is it going to take for the lice infestation? Okay, and then you immediately start scratching your head. All right, if you can,
He's incompetent.
okay. Norma, let's recall this in 3 weeks.
Okay.
All right, what date?
I think it's February 8th.
You know what, do it the following week, I'm sorry. Yes, February 15th. Is that okay with you, counsel?
Yes, Judge, that's perfect.
All right. I see the vacation photos.
But I'm in but I'm not saying Thank you, Judge. I still have one other case.
All right, sure. And Norma, I need the files on Pete Garcia that have been dismissed. Arturo Lopez. Where's the attorney? Just have a seat. We'll wait for your attorney. All right, everyone, as soon as the court reporter comes up, we'll take up Mark Hernandez. Is that you?
Yeah, the state didn't have any objection. We just want to do a push. I don't necessarily need a record if you don't.
All right. What is happening with his case?
Well, Judge, the probation thought there were some positive UAs for alcohol, but he's diabetic and they have proof of that, which would cause the false readings for alcohol. So he's completed everything. My understanding, the state didn't have any objection to the early termination.
All right, so he's not here.
No, he's present right here. Judge.
All right, why would he show up late?
Judge, I can tell you he texted me and asked if he should wait in the hallway at 9:15. So that may explain it.
All right, because we start at 9.
Judge, when I get to this court, I like to be here at 7 o'clock.
See, if you would have told me 8:30, I would have said, maybe he's
overplayed my hand.
You did. So what is probation on Mark Renee Hernandez?
I know that we spoke last week, and at the time we were opposed for his early termination. Since then, and that was mainly because we were expecting a violation report and a motion to revoke to be presented to the court for alcohol use. However, since then, we have received medical documentation that Mr. Hernandez has diabetes, and so it's going to come up positive for the glucose on the alcohol. He has completed his intensive outpatient treatment. He's up to date with his fees. Everything else is going rather well. I did speak with the manager and I spoke with the supervising officer, and they have no opposition at this point for early termination.
All right, and the state has no opposition?
No, that is correct.
All right, so let's do this. I want a UA.
We'll come back positive for alcohol.
Well, it shouldn't, no, because they don't test for alcohol here.
Okay.
So I want a UA.
Okay.
And if that UA is negative, then I will proceed how I will proceed.
Okay.
Mr. Hernandez, what are going to be the results of, come forward, what are the results of this UA going to be that you're going to take today?
They should be negative for everything.
All right, so we'll do a UA. Are you prepared to go now?
Yes.
All right.
I'm going to run the computer and I'll come back in a couple minutes. Sure.
Alberto Camacho. The attorney for Alberto Camacho.
Judge, that attorney is still another hearing.
All right. The attorney for Arturo Lopez.
I think he's, I believe that'll be lead judge. I think that's, yes, ma'am, that'll be a plea. Mr. Cantrell stop by, so I'm making that paper.
Okay. All right. Once they're not ready on either of these.
Mr. Mitchell? Jonathan Mitchell?
Jeremy Duke. Oh, Norma, if you call back Teresa Garcia, because she also has, okay. Jason Wilson. Good morning. Oh, no, he's here?
Yes.
Are you all ready? All right, you're on this side. I don't know why you keep coming to the middle. You're on this side or either that side. All right, could I see the file on Jason Wilson, please? Have you conferred with the state?
I have your own.
All right, this is Criminal Trial Division. And is this a motion to modify?
It is your, it's also an occupation or a request for an occupational license.
All right, so the court doesn't have any of those motions. So as soon as they're pulled, we'll take it up. If you'll have a seat. Caleb Crum. Good morning.
Zach and I have been conferring on this one. This is the one where there was confusion about mental health providers. I've spoken with Kelly Bernstein. She is willing to do the evaluation that I was wanting, which is for purposes of maybe some guilt and innocence, but mostly for punishment if it becomes necessary. In our discussions last time, it became apparent that you thought I was originally seeking competency, but when we talked further, we agreed that maybe it was a good thing to be done. I hate to say it, I thought I'd put these in, but I guess they got lost in the holiday shuffle. My kids had some health issues, my parents had some health issues, what it is. Okay. Since then, Mr. Crum has been arrested on 3 new misdemeanors on the same day, but yeah, 3 new misdemeanors all the same. And you revoked his bond. I don't have a motion to set bond in front of you. I don't know if you need one or if you can do it on B page, but Zach and I have agreed on 30 when he was.
No, your client will need to be here.
Understood. Okay. I was hoping to get the bondsman prepared with the money ahead of time. But
yeah, he'll need to be here.
Right.
So
could you tell me if you're inclined to grant that amount?
I mean, I don't know until I hear things. All right. So are you going to have your own mental health expert or are you going to go through the county?
So I was thinking both. Mine wasn't going to be looking at competency necessarily, but how his brain works when it comes to reacting to stimulus around it based on his prior diagnoses for purposes of A, mens rea for guilt and innocence, potentially, and then B, for if he is convicted as a mitigation expert at the sentencing range.
Okay, so in order to approve this, do you have an idea?
Yes, Judge. I have the 2 orders. Sorry, I thought I'd put them up there.
No, I have this motion.
You asked me prior to this to bring an updated order for competency and this, so that's what I have here in my hands. And Bernstein, it has her rates. I was going to be asking for about 700 to start on Miss Bernstein.
That would allow her to go over medical records and have about 2 or 3 sessions with him to get an idea. And then my goal at that point was if I felt it was going to be important for trial purposes, I would come back and ask for additional funding at that time.
Okay. And you still want the competency eval, correct?
Yes, Judge, because if we were to private pay for that, the amount of time that she'd have to spend, I'd have to ask for more. So if there's a built-in mechanism within the county and he qualifies, I think you're in agreement that he does, then it probably makes most sense financially for the county to have someone who's already on payroll, so to start do that.
All right. Ms. Ferguson, on this case, it's not on the docket, but the competency request has been signed. So you can make sure that doesn't get lost in the shuffle. And then if you want a copy of the order that the court has just signed, you can have that.
Perfect. And you did 700, Judge? Or?
Yes.
Okay, perfect.
Ms. Ferguson, this belongs in the file.
Okay, excuse me.
Yes, if you want to make a copy of that, you can.
I will. Thank you, Judge.
All right.
Have a great weekend.
You too. Teresa, who do you have?
Judge, I have Jesus Nato Trevino.
All right, Jesus Trevino.
Judge, I was appointed to this case in December, and I didn't have any locating information. He was out on bond. And this is the first time I'm able to have a conversation with him, and I will be filing a competency eval.
Okay.
He has this case, and then he's got a night mag case, Judge.
All right. All right, Ms. Garcia. We're going to recall this back on February 15th as well to make sure we are where we need to be.
Okay, Judge. And, yeah, Trevino. And Judge, do I file it directly through e-file?
Yes. Ms. Ferguson, on Jesus Trevino, that's going to be a request for a competency evaluation. And so we're going to recall it back with her other client on February 15th, just to make sure everything is in order and he doesn't get lost. And that's Jesus Nato Trevino. That's on page 6.
Thank you, Judge. May I be excused?
Once he signs the reset form. Do you have a question, sir?
No, I just wanted to know a little about my character. Even though I had some record from something from the past when I was young and dumb, I'm not a bad person. I do work, and so I'm getting back on my feet. I'm having this little bottom of a daily theft that keeps on getting in the way of people stating my identity and using it and so on and so. But I won't let that stop me. I'll still continue to get back on my feet, work, and so I still have a job that I just started.
Right, Mr. Trevino, I want to let you know that when people come before me, I don't see people as criminals or anything of that nature. I see people as individuals. So your past is your past, and sometimes past has to be considered, but I view cases with an open mind.
Correct. Just to let you know that here in court, I will tell you the truth, no lies at all, because I want the truth to come up to the table.
I appreciate that. Thank you so much.
Thank you, Judge.
All right, once you sign the reset form, you're excused. All right, is the party here on Nicholas Aguilar?
Yes, Judge.
Good morning, how are you doing?
How are you?
Oh, I cannot complain. It's a beautiful day outside.
It is a really nice day.
I'm currently alive. I mean, you got to be happy about that.
Absolutely. Good morning, Your Honor.
Good morning. All right, so today an offer was due.
Yes, sir. You can get it.
Okay.
this time my client is not inclined to accept it.
All right, Ms. Ferguson, can we recall this in 3 weeks? That will be your plea deadline date. After that time, if you choose not to accept the state's offer and an agreement is not reached, the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court and you'll be headed for jury trial. All right, what date, Ms. Ferguson? All right, we're coming back on February 6th. That's your that's your plea deadline date.
Thank you, Your Honor.
And if the state is ready and they want a jury trial on that day, they'll be able to go to jury trial on that day.
Want to go through it for the rest of my life.
Are y'all ready on Tony Torres?
Ready. Necessary. Are we approach?
Yes. State, are you ready?
You can reach what's 3 minutes.
All right, court is calling 2023 CR 10354, State of Texas versus Tony Torres. Could I have parties announced for the record for the state?
Hearing us, Washington State of Texas.
Defense.
Jonathan Michelle for the defendant. We're ready.
Are you Mr. Torres? Counsel, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Torres, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Yeah.
Mr. Torres, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it? Excuse me. There's somebody coming up behind us. All right, did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea you were giving up those rights? Did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do. Just for the record, Judge, my client's made me aware that he has a learning disability, that he is bipolar. I've spent plenty of time with him. He understands what a jury trial is. He understands that he has the right to go to trial. He understands they're offering probation, and he understands what's going to happen if he doesn't follow the rules. So I joined him in his waiver, asking the court to accept the plea agreement.
All right. And do you believe he was sane at the time of the offense?
Yes.
Mr. Torres, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am. 100%.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, punishments to be assessed at 4 years in the prison. There's a $500 fine. State recommends community supervision. There's to be ignition interlock for half the term, DWI intervention, VIP, and the 2-year driver's license suspension. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge. He's on home monitor right now. He is not driving. He's not driving the vehicle.
State?
Yes, sir.
All right. Do both parties understand if he presents the court with an affidavit of non-driving and an affidavit of non-ownership of a vehicle, and there is no vehicle that he has access to, then the court will order SCRAM or some sort of mobile device and not the ignition interlock. Does everyone understand?
We understand that, Judge. We've already turned that into.
All right. So I know your plea bargain agreement stated for ignition interlock to have the term, but are you okay or in agreement with there being a monitoring device, mobile monitoring device?
Yes, Judge, that's just so that we can kind of make sure that we go with the fact or the assumption that they may have a power.
All right. Going to show you what's entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Counsel, are there been any such motions?
None.
I keep looking this way. Showing you outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 120 hours of community service restitution, and 10 days house arrest in lieu of 10 days in the Bexar County Jail. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
It all proceeds to this one more happens.
No objection.
All right. And state, are you going to have any objections to the 10 days house arrest?
No.
All right. Thank you. You may continue to confer. Mr. Torres, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it and did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
No, Your Honor. We're asking to accept the plea agreement. He's done probation before and he's assured me he can follow the rules again.
All right, are you employed?
Oh, no, it's good.
And what is the SSI for?
That's for learning disability.
Okay. Do you live with anyone?
Well, I have my own place, but I stay with my mom. I live by myself.
Do you have any children?
Yes.
What are their ages?
16, 14, and 4.
All right, and do you have contact with them?
Yes.
How often?
All the time. All the time.
All right, and what is up with the tattoo?
What's my daughter? Her left feet.
Her what?
Her feet, date of birth, her name.
All right, this is what the court is going to do. Court is going to sentence you to 4 years in the prison. The court, of course, is finding you guilty. Suspended and probated for 4 years. There's a $500 fine to be probated. Admission interlock for half the term. If he provides proof, and I see in the report that he's provided proof of non-driving. Once he provides proof of non-driving to probation and also non-ownership or non-access to a vehicle, then the court will let him remain on the monitoring device that he's currently on. And that will be for half the term. There's to be regular reporting by Zoom or in person, regular random UAs, $120 hours of community service restitution. If he would like, he can donate those hours at $7.25 per hour. Always tell people the food bank because there's always a shortage. But if there is some other charity you would like to donate to, you're more than welcome to donate to that, but not the human fund.
No, I've done it to food bank.
You know what that is, right? All right. There is to be, since you don't work, it's going to be full house arrest for 10 days in lieu of 10 days at the Bexar County Jail. And that's due to, now there's a lice infestation there. That's due to that and because of the uptick in COVID. So on that full house arrest, you're in your home for the 10 full days. You're not allowed to leave that home for 10 days. You understand?
It can be a memo. It can be a memo.
I mean, if your mother wants you to live with her, then it's 10 full days at your mom's house. But once you go, you can't leave.
Yes, I'll be there.
All right. There is to be proof of employment or SSI within 30 days. No employment as a home health care provider or with minors. There is to be 2 years driver's license suspension, DWI intervention, VIP live, DWI education, a referral to felony drug court, TAP evaluation out of custody, and probation will follow TAP evaluation recommendations. If they request inpatient treatment, we'll start with intensive outpatient treatment. So either way, we'll start with intensive outpatient treatment if he's not accepted into felony drug court. And there's going to be 90 sober meetings in 90 days. Probation, is there anything else he needs? Yes, please. And if he completes parenting classes, he can use those in exchange for the community service hours, or either he can pay off community service hours. So you can either pay it off, but if you complete parenting classes, then the court will consider those hours satisfied. Oh, thank you. Field visit, or more action. All right, is there anything else you need from the court to be successful? All right, I'm gonna show you what's entitled Trial Court Certification of Dependents. Right to appeal, did you read that with me? Did you understand it and did you sign it? Because this is a agreement, because I put you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So I'm hoping you're going to be successful at this. If there's an issue, let probation know. If you feel like they're not addressing it, you can always come back to the court. You understand? And let me just tell you this. When people drink alcohol, nobody ever expects to get intoxicated and kill somebody. But sometimes that happens. Don't be that person who goes out, drinks, and you end up killing somebody. No alcohol for you, and you're not allowed to have alcohol, period, while on probation. You're not allowed to smoke marijuana. You can't have alcohol in your home at all. All right, good luck.
That's all I have for the document.
All right, thank you. Thank you so much.
Well, you're reaching down there, if you want to, I appreciate it.
Tracy Valdez. And this is an application probation. Court is calling 2023 CR 11178, State of Texas versus Tracy Marie Valdez. Could I have parties announced for the record for the state? Defense?
Bridget Gossip for defense.
Are you Ms. Valdez? What will? Counsel, I'm showing you what's entitled Acknowledgement of Discovery. Have you received all the discovery? Did you review that with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Ms. Valdez, showing you what's entitled Application for Community Supervision. Did you review it with your attorney? Did you understand it? Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with possession of a controlled substance, penalty group 1 less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Valdez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, punishment is be assessed at 2 years in the state jail facility, $500 fine. State recommends community supervision. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 3 years. There'll be a TAP evaluation and community service restitution hours. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. I offer State's Exhibit 1 in the attachments.
We have no objections.
Showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes. Your Honor, we're asking the court to follow the recommendation of the ADA. Ms. Valdez is 38 years old. She is homeless and she will continue to be homeless. She plans to reside at the Haven for Hope. While in custody, she has taken it upon herself to take courses in the reentry classes to reenter society. She's taken anger management courses. She's taken AA meetings at the jail. She's taken social classes there at the jail. She has been in custody for 127 days. So she is willing to comply with any conditions that the court may impose upon her. So she's asking the court to follow the recommendations.
All right. Do you have any children? All right. Do you have any family support system here in Bexar County?
Yes.
And who would that be? And what about mother, father? I'm sorry to hear that. All right. When's the last time you had employment?
It's been a while.
How long?
Ever since
All right. So you're going to have to get employment. Do you understand? All right. So have you talked to somebody or had therapy to address the issue?
Yes, that's in the reentry.
Okay. All right. This is what the court is going to do. The court is going to find you guilty, sentence you to 2 years in the state jail facility, suspended and probated for 3 years. There will be 100 hours of community service restitution. She's to reside at Haven for Hope. Of course, if you're able to get housing, just let probation know. I'm going to run a referral to felony drug court. If felony drug court accepts you, and they will, if you're honest with them about your drug use, and they will help you with housing, they'll help you with employment, they'll help you with any trauma or therapy you need in regards to your family. You understand? There is to be regular reporting by Zoom or in person, regular random UAs, a TAP evaluation. I'm going to want a MIC evaluation. Felony drug court, that's going to be done while she's in custody. They should be able to see her. Next week is a short week. So no later than 2 weeks, they'll be able to evaluate her and see if she's eligible for their program. I'm going to want field visits 1 time per month for 4 months. And then thereafter at probation's discretion. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. I'm going to want the TAP evaluation, MIC evaluation, and felony drug court evaluation in custody. Of course, if felony drug court accepts you right away, they'll probably remove you from custody and the MIC evaluation and TAP will be done out of custody. Probation, is there anything else she needs? All right, is there anything else you need from the court? All right, and I'll do no unsupervised contact with minors. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. We're off the record. If you need anything, let probation know. If you feel like they're not addressing it, you can always come back to court. All right? Thank you. Who is here with the interpreter? All right, let's take your matter up. Who's your client? All right, so this, Norma, we're gonna have to bring this back at 1:30. Council, we're gonna have to bring you back at 1:30. Yes, because I have to go visit the juvenile detention center. Jasmine Hunt. All right, are there any witnesses on Miss Hunt?
No, Your Honor, just a procedural matter right now.
Oh, sure, come forward.
I'm a status matter for this.
Sure. Yes, what is the procedural matter?
Speaking with probation on, we were trying to get her into mental health court here on this PD. I understand she's up for another evaluation or meeting this coming Tuesday, Your Honor.
Okay.
So we wanted to keep it, I wanted to keep it kind of close tabs on it because she's been in jail for so long.
Okay.
We were thinking about maybe next Friday or so, recall it.
All right, let me see. Norma, are we able to recall this on Thursday, the 18th? All right. Probation on Jasmine Hunt, it's going to be recalled on the 18th. Council said that there are some other evaluations. All right, Ms. Hunt, we'll see you back on the 18th, okay? All right, everyone, I am sorry. I know that you all have cases that are pending, but I'm supposed to view the juvenile detention center. So that's something I have to do. So we're going to come back at 1:30. And so the people coming back at 1:30 will be Devin
Good, I put a live feed.
Anything further? No, thank you, Judge. Case number 23, 4457801. All right. No, we're not. That's not the case number, and I do apologize. 234456901. Okay, Ms. Stevenson, you may continue.
Thank you so much, Your Honor. We thank the court for an opportunity to just kind of let things calm down a little bit. So I guess my first observation, Your Honor, and I have had the opportunity, and Ms. Jackson has had the opportunity here with Ms. Vincent has had to say about the incident, but I just don't believe, Your Honor, that regardless of what was happening with the felony case, if the events had transpired in a way more consistent after with what the victim has testified to, I don't know that the people would have made themselves the people in this courtroom would have made themselves party to the global resolution, Your Honor, landing us where we are today. I do believe that, review of the video surveillance by the people, in consultation with the victim, Your Honor, led the people to make the offer that they made to not only reduce or dismiss the more serious misdemeanor charges, Your Honor, but to dismiss the felony charge as well. As Ms. Vincent has alluded to, there has been ongoing conflict between these parties, Your Honor.
Have you ever thought about what happens to appliances that are sent back, returned for tiny scratches, or were simply overstocked? There's a lot of reasons why a perfectly good appliance is returned or never sold. At American Freight, we buy these name brand appliances and inspect, repair, then test to sell to you at significantly reduced prices. So next time you're shopping for an appliance, check us first. American Freight, slightly imperfect appliances for the perfect price.
One simple but brilliant trick to heat your home in 90 seconds and save thousands of dollars on your heating bill this winter. This genius way to heat any room for almost zero cost is taking over the market like crazy in the US. An ingenious college kid from Fairbanks, Alaska, just destroyed the billion-dollar heating industry by building a device that can heat any room 90% cheaper than traditional heating methods. Martin designed the invention after budget cuts left his school with a broken heating system in freezing cold winters. He and his fellow classmates had to study for their exams in 55-degree temperatures. And when their plea for a new heating system fell on deaf ears, Martin decided to take matters into his own hands. Blessed with a gift for engineering and a desire to help his classmates, he was able to reverse engineer common air heater units. Using the Joule-Thomson physics principle that powers all major types of heating systems, he built a one-of-a-kind device that creates a perpetual heating loop, recycling the heat that's generated so that none of it goes to waste. Brought the super cool gadget to school, and the results were incredible. Under controlled testing, temperatures in the bitterly cold classrooms rose from 55 to 75 degrees in just 2 minutes while using 90% less energy than regular heating systems. After word got out about what he'd made, investors quickly lined up. He was told by his professor that he would go down in history, but when a heating company approached offering millions for the right, Martin flat out refused and was expelled 3 days later. It was then he realized how big an impact his device could have. Partnering with top engineers in this field, they perfected the prototype and readied it for mass production. It's called Heat Pal, and it heats room rapidly using only tiny amounts of electricity, recycling warm air so that practically no energy is wasted. Heat Pal heating capabilities are simply unmatched by any regular heating system. Thanks to its brilliant ceramic heating technology that passes air over a precision-engineered heating element, it heats rooms in a matter of minutes for pennies per day. It has actually been tested to be 97.8% cheaper than standard heating systems. Just plug it into any power outlet in your home, adjust the temperature, and Heat Pal will heat up your room within minutes. It works in rooms up to 700 square feet in size. When Martin first launched Heat Pal to the public, it spread like wildfire, and after going viral, it sold out within the first 48 hours, developing a wait list of over 50,000 orders. Martin wants everyone to know about this new technology and orders it within the next 24 hours. This is a great deal, and it might be taken down anytime, so it's best to act now. My advice: grab yours before this super low price is raised. Click on the link on this video to visit the official website and order with 50% off.
Much of that conflict, Your Honor, resulting in Ms. Vincent receiving, some having been on the receiving end of police contact, Judge. So Ms. Jackson is here to accept responsibility, as she stated in her description of the offense for being in a public place, a gas station, getting into this loud argument with the complainant, and she's indicated that that's where it landed. I hate these neighborhood dispute cases, Judge, because it's so hard to just muddle my way as defense counsel through them. But we are where we are, and where we are right now is a disorderly conduct. And that Ms. Jackson has admitted to behavior which is consistent with that charge. And the incident does not happen in that. Ms. Jackson has been, inordinately in terms of where we are in court, animated, and I believe she's adjusted her behavior. That behavior that was not directed at the court is directed at the volatile situation that we hope has come to an end. I just hope that these people are going to be able to if they're going to live around each other, they'll be able to live around each other peacefully. But Ms. Jackson, at this point, Your Honor, does stand convicted of disorderly conduct. And that is after the felony prosecutor and the misdemeanor prosecutor had an opportunity to look at their cases and make a decision as to what the evidence would allow them to be able to prove beyond a reasonable doubt. And they've landed at disorderly conduct. That's behavior that Ms. Jackson has admitted to. And I haven't, again, I don't know if I overlooked it or what, but I didn't see a plea agreement that talked about restitution. So I didn't talk to my client about that, Your Honor, but Ms. Benson would not be without remedy. She would have an opportunity to present her case in civil proceedings and try at that point to use whatever evidence is available to her to substantiate her claim for restitution. But Ms. Jackson has pled guilty to being in a loud argument with Ms. Vincent, and I believe that the people, based upon their global resolution, agree with that. So I would ask the court to not do restitution at this time, Your Honor. I would ask the court to forgive Ms. Jackson for her behavior this morning, which was earlier this morning, which was really inappropriate. Her frustration is not directed at this court. That frustration is directed at this entire situation. And I think that everybody, including myself, would be able to benefit from some anger management. So I don't think that's going to be harmful to Ms. Jackson in any way. But I would just ask that the sentence, Your Honor, be more in line with the crime to which Ms. Jackson has admitted responsibility. She is working on taking care of these outstanding warrants. I want to address the elephant in the room that what I believe to be an elephant in the room, that Ms. Jackson doesn't have a driver's license, but the evidence does show that she drove. So the probation department's recommendation that she take the driver improvement class, not drive without a license, that she get a driver's license,
Get yourself a new look for your home for the new year at American Freight. Want to upgrade your appliances?
the obligations in Farmington, I think that she'll be on her way. I think all that kind of stems from the same situation, that she'll be able to move toward getting a license. So certainly no driving without a license. I don't know about getting a driver's license. I would ask the court not to do any restitution at this time. Absolutely no objections, no contact between the parties. But I just ask that the sentence follow the charge.
Would Ms. Jackson like to make a statement on her own behalf? I say something, Ms. Stevenson. I'm asking you, would Ms. Jackson like to make a statement on her own behalf?
I apologize for that, Your Honor. I believe that I didn't see it was that she was muted. I believe that Ms. Jackson would like to address the court. Ms. Jackson, if you could unmute at this time. Go ahead and unmute for us. There you go.
Good morning.
Great. And would you like to make a statement at this time, Ms. Jackson?
Yes, I will.
Okay.
So, I apologize to I didn't mean to make you feel disrespected in any way. Me rolling my eyes or anything. I didn't mean for you to feel disrespected. On behalf of my case, Miss Darla, me and Miss Darla, she said we had back and forth for a long period of time, but it wasn't actually me and Miss Darla having a back and forth. It was her and one of my siblings that she had a back and forth with. The only reason I went up to the gas station that day is because my youngest sibling had already gone to the gas station. Jamal, which is the one that said that was Monique, the one that she said that was outside with me, but we were never outside together. I was already sitting in my car that day, and Monique just happened to come outside and walk to the gas station. Next thing I know, Miss Darla was walking to the gas station. Now they're the two that's been having this ongoing battle back and forth. So I knew that it was going to be a problem at that gas station with them both being there. I only went to the gas station to get Monique in the car, and I wanted to talk to Darla that day. I wanted to talk to her to try to stop some of the drama that's been going on back and forth. That's it. Talking with her did not go well. I want to say she's not easy to talk to. So we started arguing. Me putting my hands on somebody. I'm in school trying to be a nurse. I also work two jobs and take care of another person for the state of Michigan. I don't have time to be out here catching cases or doing anything. Yes, I'm 40 years old. This is the first time I've ever been in any trouble like this. Yes, I do have tickets in Farmington that I need to take care of, but just getting in trouble and arguing and fighting with somebody out on the street, I do not do at all, period. I just wish this never even escalated to this point to where I would have to go through this, but I did. Very, very much so a learning experience. But I never had no bad intentions toward Miss Darla. I always thought she had I know she had an issue with my family. But other than that, I mind my business. The only time she see me is when I'm going in and out the house to work to school, back. That's the only time she really has seen me. The most she ever talked to me is in the gas station that day. So her stating that it's been an ongoing and that I got pissed on my
car windows, my car is a fishbowl, Your Honor. You can see right through.
Looks like you won something there. This my test guy switched to H&R Block. Their experts can do your tax.
All that. It's not a car that has tinted windows, period. So I don't know why she said that, but whatever. I don't. All I really want is peace. That's it. We stay right across the street from each other. When I walk on my porch, her motion lights to her camera go off. She's watching. She's good. She even will step out as soon as I step out sometimes. So I just want peace. I don't want no more drama after this. This has been life-changing for me to have to go through this. I've never been in court so much in my life. So I just want peace after this. And not only have it's been me and my family, it's all the families around us. All the family down this block has issues and court issues with Miss Darling. But nobody is catching on to who the problem is. I just want peace after this. And that's all.
Ms. Ritter, can you address Ms. Stevenson's issue about the restitution? She said she didn't that your plea agreement did not include restitution.
Well, it was a recommendation based off of the information received from Ms. Benson. I don't have any receipts. I know that the restitution.
I'm saying, address to me why I would even order restitution on a disorderly disturbance case, and Ms. Stevenson said it wasn't a part of the proceeding. I mean, it wasn't a part of the agreement.
Judge, this stated in the sentencing, there was a recommendation that was similar to the underlying assaultive charge in H. So that's why the people recommended the restitution, if there was any, for any out-of-pocket medical expenses arising from the underlying charge.
But it's not allowed unless it's an agreement, isn't it? So that is how. My question is more to what authority does this court have to order restitution on a disorderly disturbance case unless it was a part of a plea agreement? For a disorderly disturbance case, it's disorderly disturbance. I mean, so Ms. Stevenson is saying she didn't agree to any restitution as a part of this plea.
I understand, Judge, what the court and what Ms. Stevenson is saying. Again, Judge, that was part of the plea agreement for the recommendation.
I still don't understand what you're saying. You keep saying that was a part of the plea agreement, but it wasn't. You're saying that's just the people's recommendation.
Correct, Judge.
Oh, okay. Okay. So I'm ready to impose sentence. Mr. Flanagan, I do apologize because, of course, you're aware that I am away from.
I forgot when I first.
Excuse me, Judge. I don't want to interrupt. But you are, and this is inappropriate. Victims give victim impact statements, and that's it, and that's all. That's it. Ma'am, I would hate it. I would hate this to turn a different way. Victims give victim impact statements, and that's it. Now you all are going to stop. You're not going to hijack my courtroom ever. except for the questions that I asked at the very beginning, I let you make a statement. It's one of the longest victim impact statements that's been made on.
Hey, Alex. Hey, I love the new location. Yeah, business is great, but it's getting harder to budget and plan when bank fees are chewing through my profits. You know, US Bank has a business checking account that has no monthly maintenance fee and smart tools that make forecasting cash flow a walk in the park. Nice. Planning can be rough, but this can help a lot. I could even start that pet shop on wheels I've been saving for. See? Just trying to throw you a bone. Oh, I guess I'm not the only one. No. Business checking accounts that do more for your business.
Because victims have a right to give a victim impact statement. And really, the giving of the victim impact statement in this situation was grave because she is charged with disorderly disturbance. According to the Victims' Rights Act, there is no victim on the disorderly disturbance case. But I allow you to make a victim impact statement and then you're going to interrupt and just hijack my courtroom. This is not appropriate. It's not appropriate. It's just not appropriate. Now I'm ready to impose sentence. Mr. Flanagan, I don't have the form with me, so it may not just be in the order that it normally would be in. All right, so let me say, again, and everyone knows I hate neighbor disputes because when you go home, you're supposed to, when you have a hard day at work, when you meet something on the street, strangers, when you encounter situations out and about, when you go home, that's supposed to be your place of rest. That's why domestic violence cases are so serious, and a child abuse case. I mean, children, when they go home, they should be saved. People in relationships, when I go home, I should be saved. But neighbor disputes, sometimes they baffle me because you never have to speak to your neighbor. Like you never have to ever speak to your neighbor. Like you literally never have to speak to your neighbor. You could pull in your driveway or, depending on what side of town you live on, because some neighborhoods, some people don't have driveways. And then you just pull in front of your house and you park and everybody should understand, like on the streets where there are no driveways, that you're not entitled to the parking space in front of your house. You just are not entitled to the parking space in front of your house. So you have to just park where you can park. And so when you have a neighbor dispute, I wish that mediation could work because it's better for neighbors who have to live amongst each other to work things out, right? That's what's better. But obviously that doesn't occur in many situations. This document. I've listened to everyone today. I've listened, despite the fact that it is something in the atmosphere that everybody that has come on here almost has been rude and disrespectful to me. And at a certain point, I'm 57 years old. So I'm 57 years old. And what I didn't do is go to law school, accept an appointment from Governor Granholm, run for election 2 times. I didn't do that and say, because I love being abused and I love people to disrespect me. And I just want to get up every morning and go to a place where I'm abused and disrespected and mistreated. So it's just amazing to me. Many times, this is my first opportunity to even speak with the people involved in the case. Yet, I'm the person that, people take their frustrations out on. And I guess that is a part of the job. And I've listened to both of you, and both of you have been disrespectful. gave the resolution that they gave. I don't know. I have no idea why they dismissed the felony cases, why they dismissed it. It could be for a number of reasons, and it could be, you know, if the witness is yelling at you and being rude and disrespectful. But I don't know what goes into their decision making. That's not for me to know.
Yeah.
But Ms. Jackson, you came to my courtroom on the day of your sentencing and you were rude and disrespectful. And then everybody is expecting, you expect me to give, you know, the probationary sentence. And let me say this, I learned or I was very, I watch a lot of court TV. A lot of times it's because I'm trying to learn things. I'm trying to learn certain things when I'm watching court TV, right? And there was a judge the other day that got attacked. There was a judge that got attacked. He was getting ready to impose sentence, and the defendant left all the way across the thing and left all the way across the desk, right? And then he tackled her down. They since charged the young man with attempted murder. And
Download Klondike Adventures for free and start playing now.
At Laura Buick GMC, buy online truly means buy online.
if we were in person, if everybody was in person and not just Ms. Benson, I can see how this situation would have got out of control, and my courtroom would probably be full right now with 2, 3, 4, and 5 officers. Because there's not going to ever be a day. There's never going to be a day when I'm going to come to work and not be in charge of my courtroom. And you all have been disrespectful and unruly. But what I learned from the judge, she went to the hospital. The young man almost looked like he was about broke her neck. He was probably very fortunate that when he landed on her, he didn't break her neck. But she came back 3 days later, 3 or 4 days later. And she was careful to make sure that everyone knew and that the record was clear that the sentence that she was getting ready to impose was the same sentence that she was going to impose before that young man attacked her. Now, I use the sentencing and what the victim says and what the defendant says to help me fashion a sentence that is appropriate. When probation gives me a pre-sentence report, it is a recommendation. It is a recommendation. When I hear from the victim, I take that into consideration. I took everything that Ms. Benson said into consideration. Every single solitary thing. And I'm thinking, this is something, and Ms. Jackson must be a pickle. Until I told Ms. Benson to stop talking because her term was over. And then like night and day, Jekyll and Hyde, that switch was flipped. And had I been in person, it probably would have been a different situation. And then she didn't do it one time, she did it twice. So now all of a sudden I'm saying, uh-oh, maybe Miss Jackson, when she gave her calm statement. Now, Miss Jackson gave a calm statement after she had to be sent to the breakout room. She had to be admonished by the court. The problem with this neighborhood dispute, because both of you blaming the other person. This family, this. Well, let me give you both of you a news flash. It's both of y'all. It's everybody involved in the situation. It's nobody has a calm mind to try to resolve conflict. It didn't even make sense that Miss
A large mushroom pizza.
We're here with your attorney, Mr. Adams, and the state's attorney. Earlier, you pleaded guilty to the second-degree felony of robbery. The pre-sentence report has been prepared. If the parties had an opportunity to review it? Yes, sir. Any corrections or changes to it? No, sir. It's made a part of the record for all purposes.
5 minutes later.
Somebody, I didn't understand. Just what happened here. I'm reading the pre-sentence report and it doesn't make any sense at all.
Yes, Your Honor. The victim in this case advised that she was, her neighbors were going out of town. She was going over to feed the animals. That her ex boyfriend, who she has a child with, showed up while she had left the baby in the car with the car running at the neighbor's house.
Yeah. So far, that's what I'm reading. Yeah, but
he shows up, tries to get her in the vehicle and take the baby. He pulls out a taser. And she grabs the baby. They kind of fight over it, and he tases her. She said it did hurt a little bit, but then he takes her vehicle and flees, and he was not apprehended till sometime later. So he went, I believe, somewhere in northern Texas. He had also to mention, I don't believe she had saw the defendant over a year at this point, so it's kind of out of nowhere where he showed up.
that's okay. All of that I understand, but that's not what the indictment says. You didn't say anything about what the indictment says. It says cause bodily injury by striking the victim with the automobile.
This was, Your Honor, it was re-indicted.
It was.
Yes, Your Honor, to a robbery. It was initially filed as an aggravated assault and cause number 22-41243. It was re-indicted to cause number 23-41313, which is a robbery. I apologize, Your Honor.
Okay. I'm following you now. So yes, we've got 41313. Okay, I understand now. You pleaded guilty here earlier.
Yes, I do.
Pre-sentence report was prepared by the probation office. Everybody's had a chance to review that.
Yes, Your Honor.
And there are no changes or objections to it?
No, none from the state.
All right. Then it's made a part of the record for all purposes.
Anything you want to say?
Yes, Judge. And we was wanted to point out, Judge, on the PSI on page 4.
Yeah.
I think one of the biggest things in his advantage is the screener.
No, let's walk back. Page 1.
Right. He's talking about
Let's see.
I see. I know.
I told her to get in the car, and even though I did have a taser, I did not use it.
Never used.
Well, isn't that interesting? Because you pleaded guilty under oath to intentionally and knowingly causing bodily injury to the complainant by tasing at Ashley Bureau. So who did you lie to? My officers or me? You can't have it both ways. You're not going to play games with the court. All right? Can you explain that? I just lied. You lied somewhere. Here, you lied under oath. Then when we put you under oath, when you said I plead guilty, are you pleading guilty voluntarily? Yeah. All the elements of the crime. When you said yeah, and then you turn right around and tell my officers, although I had a taser, I did not use it. Why would you screw up like that? Why would you lie?
I just copped out to it because I thought maybe it would be a great deal.
Say that again?
I don't really understand. Like I just
wait. Do you understand the truth versus a lie? Are you telling me you committed perjury when you pleaded guilty then?
You draw less attention as what is it?
She does it this way. She can't pay for shipping all over and all over.
No.
maybe.
They do it? No, I do. You feel better?
Which is another criminal action.
No, sir.
You committed perjury when you pleaded guilty to this crime, which says you tasered her. That's what you swore under oath.
I did those crimes.
Is that right?
Yes, sir.
So you didn't tell the probation office the truth.
Yeah, I'm sorry for this. I'm sorry.
Right. Anything else?
There's a reason why I was going to ask you to go and see the people on the probation. As I was saying earlier, I think the good thing is that the score is a low risk level. So I thought that's something positive. that he's not gonna be a big risk if he's on.
I know. It begs the question, so why is he here? He's such a low risk.
Because I guess with the TRAS screener.
How many times have you been to prison? Look, I'm not talking to you. I hope I know how many times you've been to prison. Well, I'm talking to you. Why would you even answer that question?
I'm trying to help him out. I'm trying to help him. And I was just looking, I see.
Oh, look, the last time you went 4 years. Right. Time before that, let's see, you were on probation, that was revoked, and then you did 1.5 years in state jail. So you've been to a prison facility 2 separate times, not counting your misdemeanor 30 days jail in Bowie County. Is that right? Or am I missing something?
He's talking about this.
You got forgery, which is, of course, deceit, then evading arrest and detention with a motor vehicle. Later in 2017, you pick up 4 years in prison, right? All right. Okay. Go ahead.
So Judge, he was asking, will you really consider him for probation? And I understand that with this particular offense, he apologized for not being totally truthful about the tasing incident. But Judge, I was asking you to consider this is more of a crime, passion type thing, at least from my understanding. He really loves his son. He spent a lot of time with his son. His son has been a big part of his life. And when I met with him, when I talked to him,
how old is your son?
He's just turned 3. He turned 3 years old, 5'11". And what happened, the young lady in this case, the complainant, and I'm not trying to justify conduct at all, but I think that when she was not letting him actually see his child, and he had that relationship with his child, he blew up and he did something that he absolutely regrets. Now, was that right? No. But at the same time, Judge, with the passions involved, you got a man that really loves his kid, and he's going to speak for himself. I don't want to speak for him.
You were made to find new ways to be brave. We were made to unlock hotel deals because you booked a flight.
Can see the difference between like how I'm operating. Having a lot of good quality sleep is crucial to feeling good. Visit sleepnumber.com to shop.
Can you tell the judge just exactly what was the background with the kid, the lady, and what was going on that kind of caused you and pushed you to the way what you did? And I know you're sorry for what you did. What was the circumstances? Because if you tell us the circumstances, the judge might have some leniency on you. What was the circumstances?
The circumstances were, Your Honor, for 2 years, I decided that when I went back home to Texarkana, when we split up, I had hopes we getting back together, but my drug addiction with methamphetamine and stuff, you don't even have to do it. It can mess your brain up real good.
No, don't blame it on the drugs. That's your choice.
No, yes,
Your choice. Your choice. You know.
Yes, sir.
You know what it can do to you. You made a choice rather to get high as opposed to being responsible for a family.
And
you chose a selfish act. Okay. So well, that's why you're here.
Yes, sir.
In an orange jumpsuit.
Yes, sir.
Because it's all about you, which is not the way a family works.
It's not.
So tell him about what happened when you went to the kid. You was telling me that you were able to see your kid. What happened?
I moved back down here. Was in the Salvation Army trying to get myself right. And for that whole past 2 years, it was like I was paying for picture through text. And I would drive down there 350, 400 miles, and I would just want to hug. But see, that's where I went wrong, was going down there without letting her know I was coming. And I learned she can't do it like that. And she didn't want her son around any kind of meth use. And
Well, good for her.
that's true. I mean, I did that.
Good for her. You put the family in harm's way. That's your choice. That was your choice. Where are you getting the meth from again?
I would get it. I got it down here, and I got it.
Who? Where are you getting it from?
No,
where are you getting it from?
Glass House, the road, Glass House.
Who is it selling?
I guess his name's Sam. They call him Sam. I think his first name's like Isaac. I'm not mistaken, but they call him Sammy.
What about the cocaine?
And,
you were using that regularly in 2013, right?
The cocaine.
Where were you getting the cocaine?
Cocaine. That was mostly in Texarkana. I just get it from the people out in the neighborhoods.
And let's don't forget 18 years of cannabis use. Yeah. Where were you getting that from?
That would be in Texarkana also. I never really smoked anything other than this meth down here. I never used intravenous.
So it's rude, but you were never addicted to it? Any of this?
Yes, I was addicted.
Okay.
But I just decided that I just do one drug now. That I just would do one drug. I don't even smoke any weed or anything.
That's what he was asking is that when she wouldn't let him see the kid, and she had every right to him being using drugs. I think that kind of made him make an irrational decision with her because you did have a relationship with your kid. Right. And I think when she told him that you could not see your kid because of the drugs, his mind made some real bad decisions at that point. And we're not justifying it. He's just asking for some leniency. Because that was more of a passion type situation. And not being to see his kid really hurt his heart. That hurt his heart a lot.
Well, he assaults the mother in front of the child.
And I'm not
the way this goes.
I'm not defending. I'm just saying
No, that was not an excuse.
But with the drug problem, if you put him on probation with him being low risk, he can take whatever drug classes or programs that probation, and I know probation here, if they will work with him, and I guess he could do the anger management, the moral recognition classes. He could also
Anything. You've been in drug rehab 3 times. One of them is an absolute failure. But you're assuring me that you can take care of it by going back. You've been to St. Pete 3 times. That's the most and failed. What state say?
Your Honor, the defendant in this case, he wasn't able to see his child again because of his drug addiction. That was due to his own fault. Detective soon after this called Finn's mother trying to locate.
Got a large mushroom pizza.
Susan Marie, pizza again. HelloFresh has delicious guilt-free recipes you can make in a snap. Whoa, that's right.
They say better safe than sorry. And the safest bet? Cenex Maxtron diesel engine oil. The smartest oil for the toughest conditions. Because sorry doesn't cut it out here. Cenex Maxtron diesel engine oil. Oil that runs smart.
My 85-year-old mother came to live with me. Takes a lot of meds that help me quality of life. He wants to sort of things out. Never really confident. It'd be nice if it was an easier system.
Boy, this is their biggest flop ever. You think they fire everyone? Boy, this is their biggest flop. Fire everyone. Boy, this is their biggest. Boy, this is their biggest. So Oh, just doing the best I can do to make all the things so bright for me and you. To make it all right, to get it all right. Person said, they Charlie Brown, and I'm here. Hi, Kisme. How you doing? Kisme in the room, guys. I just got in from shoveling the ice. Ugh. Ooh. Public. If I have to drive my car just down the road, I smashed it. Having me screaming. Demon, across the old. Show starts at 5. I get everything ready. Ready. Yeah. When are they gonna be on tonight? Oh yeah. I don't even think we're gonna shut down, Disney. We're just gonna change the title of the show from where we got it now to Crab Dog Out. Call it a wash. What do you think? A good idea? Change the title. No one around. They don't care if it snows. But the wind is always good for the weatherman are getting fired tonight. We're supposed to have a guaranteed 7 inches. I don't see any inches. Have a good night at work. Tismy said it out, she's going to work. Like it's getting dark out there. It's getting so dark. That's when I started this live stream. It was dark. But now it's light. It's dark. Dark outside. Looks like rain, yeah. It was snow this morning when I went to the dumpster. But it's rain now, mixed with snow. 35 degrees, those weathermen are out of their mind. I don't know how they can keep a job. Seriously. Why would a news agency pay a weatherman $100,000 or more a year when he gets it wrong 80% of the time? You can pick an old Pollock that could get it right 50% of the time. And you wouldn't have to pay him but a little bit of money compared to the regular guy. Heck, I'll tell you the weather every day. Just give me a fitty ball. Just give me a fitty ball. Oh, I really need a dodgeball. I don't know. I don't think it's better safe. Maybe not. They closed schools here too, and there ain't nothing. They just closed them because they didn't want to go to work. Because the weathermen lied. So it's back to the weathermen. Off with their heads. Off with their heads. That's what the king said. Off with their heads. It's snowing outside. And the cat's fast asleep. I made bean dip today and it tasted so good. I ate a whole bowl. Yeah, there's no snow on the ground. See, they hold me up too. I was gonna fill my truck up with garbage to take out in the morning. I didn't do it because I thought it was gonna be a terrible day, but nice day. I gotta do some work tonight. I would already be done with all my work. God, it's fine. When you go down there, you better just beware of a man named Leroy Brown. Leroy shooting dice. 5, 6 foot tall. Do you have salt to throw out? No. I mean, yeah, we got salt, but I never throw it out. It's not good for the grass or the environment to be throwing out the salt unless you absolutely positively need it. I like never ever use it. Very rarely. Unless Angel, I worry about Angel, and if I can't get the ice off the stairs, then I might put a little bit out there. I'm chintzy on the salt. Yeah, it ain't good for the car either. That's right. Or anything else metal. Oh, in the air. I'm looking for baby bird. There's 3 people watching, boy. I got a good share of the market on YouTube. I'm one of the 3. At least I don't have to stand at my window. I can sit down and watch it. Oh, time to take a shower. Thank you, Tismy. I appreciate it. I do. There comes Angel. She's coming in to say hi to the world. Angel. Oh. Got a phone call, Angel. What's that be? This leather is probably not as hard on.
Waters.
Oh, You say you don't believe in Santa. Me and Grandma, we sure do believe. Me and Grandma, we sure do. I'm back. Got dog show starting. Good evening. Where that little glowing thing is gone. Good evening, Robin. Good evening, Lori. Good evening, Amy. Good evening, Anita. We made it here. Hi, Ellen's mom. Good evening. There was light from your camera phone reflecting on the door, said Laura. Oh my God. Really? That sucks. Let me make sure I got that right. That means I had the flash on that whole time. No wonder my battery was so beat down. I was wondering why the battery was so low. I had my flash on the whole time and didn't notice it. That sucks for my poor phone. Damn. That's a lot of flash time. I hope it didn't hurt my phone. Jeez. What a goomba I am for not seeing that. I can't believe I didn't notice it in the window. It really sucks. I try to take good care of this phone. That really sucks. Amy's trying to get her mom to make some tacos for dinner. Hi, Jessica. Not hot. Oh, Lord. What a long day it's been, huh? Do, 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 do. Hi, Joey K. How you doing? Mm. Joy's doing fine, except her back hurts a lot. Yeah, mine ain't the happiest either. We've been on 9 hours and 17 minutes. Rico's Monday to have the stents in his left leg replaced. They are clogged up again. Too bad they didn't have a machine that could suck that stuff right out of there. Amy's so bored, she needs to get in the gear and find her clipboard so I can color some pictures. My doctor wants me to put my feet up. How's your basement look, Frank? Boy, it looks really messy, Joy. But to me, it looks a lot better. To you, it would look just the same, probably. Hi, Laura. Laura in the room, guys. When we get another break, that'll be spring. March 21st or 20th. One of the two there. 20th of March. You'll get another break. One, two. Buckle your shoes. She's laying down. Enjoy. Hi, Mr. Lynn. Mr. Lynn in the room, guys. I'm talking about a break from things going wrong. Lori, you may have to put some stuff on the marketplace to get rid of. I'm gonna put some glass coffee table topper on marketplace and hopefully they sell. I just threw 2 of those away, Amy. You could have got 2 more. Hi, Paula. Paula in the room, guys. I threw a round one and a rectangle one away, Amy. It's the other day. Oh yeah, we got a card from Lori Chase. You guys ready to open it? Lori Chase sent us a card. We're gonna bust this bad boy down once we get it open here. We'll read it. We don't want to open with these janky ass scissors. That's for sure. Let's just use fingers. Look at that. Just the season to shine. Ain't he cute? Just the season to shine. What a cute kitty. To Frank and Angel and Baby Bear Jazzy. May your Christmas be merry and bright. Love, Lori, Ray, Colin, Savannah, Jimmy, Yvette, and Jasmine. Sabrina, Sassy, Fuzzy, Lula, Miles, Dolly, Bumbles, Fred, Wilma, Snowy, Sissy, and Baby Angel. Thank you, Lori Chase. Lori Chase, everyone. I think you need to sharpen them, said Amy. Yeah, they could use a little sharpening. They're kid scissors. They're not supposed to be that sharp. It's coming along, Mr. Lynn. I could fit a lot of bags now. If I had to, I could fit 1,000 bags. But it's still messy as hell. You wouldn't be able to tell the difference. But I can. Boom. Whose address do you need? Our address is in the description of every video, Ellen's mom, including this one right here. Look at, I got 43 thumbs up and only 21 people in the room. I'm doing pretty good. Except I've been on for 10 hours. So if you look at it that way, I'm doing terrible. Angel sneaking in the room. There's Angel, guys. And baby bear. Angel, give it to me. Give it to Ellen's ma, Angel. Paula finally got a sleeping bag for when the cold spell comes in. Yeah. I hope you don't need a sleeping bag to keep warm in your house, though. Um, Ellen's mom wants your address, Angel. Address. ADDRESSS. Frank, I feasted on spaghetti. I'm proud of you, Lord. That's awesome. That's a good meal for you. Spaghetti. You got some carbohydrates there. You got some vegetable. No, their address. Our address. Not our email. That's an email. I have a lot of drafts, Frank, and my feet freeze. It sucks, Paul. I'm sorry. That's one thing we're lucky. We don't really got a lot of drafts here. All the bedrooms here are warm. The coldest room in this house is here or the living room. Even the basement ain't really that cold. Amy told the employee at the nursing home her address was 911 Haven Drive. My mother's phone number was 911, and I gave her my phone number. Trick her into thinking it was my mother's. She fell for the trap. And when she did, I hit her with a baseball bat. It's supposed to get cold here. We'll see, though. The weatherman was completely wrong about the snow. Could he be wrong about the cold, too? Let's see when the cold's coming. Oh, it ain't coming yet. It's only going to be 26 tonight. That's not bad at all. The high tomorrow's 26, though. Then it goes down to 4, so sometime during the night. We're going to have 0 on Monday and Tuesday for highs. 0 for highs. -6 for a night high. -6. That'll feel comfortable, actually. As long as it ain't windy, but it's gonna be windy. Looks cold for a whole stretch of time here. We're not gonna get much snow this year. It really don't get cold till tomorrow night. Tomorrow night. We're good till then. Hi Tina, hi Rose. Tina and Rose in the room, guys. Frank, your snow didn't look deep because it all melted. The weathermen lied through their teeth. Y'all need to be fired. I'd fire them. I'd stop having weather on the news if I was the news station. I'd just take the weather off. They're not worth their salaries. They make over $100,000 a year. It's not worth it. I'd cut them off. We don't need meteorologists anymore. We can just look out the door and see what it's going to be. They're saying heavy rains tonight. That's good. It'll clean everything up. That's one good thing about heavy rain. What about a tornado warning? I'm sure. Let's just grab a chair and watch for a tornado. I would. I would watch for a tornado. I never seen one. Hi, Isabel. Isabel in the room, guys. I wouldn't go chasing after one like you, Amy, but I would watch one if it was coming towards my area. Laura said, I'll just turn the camera on. Hi, Isabel. We're warm and cozy. We are warm and cozy, actually. We can't complain. When the sirens went off, I was standing in the middle of the parking lot looking for a tornado, said Amy. Hi, Christy. Christy in the room, everyone. Frank, call out Judy. Judy, come to the office, said Laura. Shh. Stat. Angel, you might want to take your address out of there now, said Lori. It's gonna be below freezing for 3 days, said Christy. Yeah, up here too, Christy. Ellen's mom said, we're colder too. I'm getting colder too. Is Jay done? Oh, is Joy done? You mean, Ellen's mom? Yes. Uh, there goes our gas bill. Luckily, we pay the same amount no matter what. $135. Gas and electric, same thing. Isabel minus 13 Celsius here. Christy's ready for the warm weather. Amy's not looking forward to going outside to her doctor's appointment during the winter. It's almost over, Amy. Winter's halfway over. We're almost there. Barberry to the office, said Robin. There goes my electric bill, said Christy, out the window. Amy said when my insurance company vehicle picked me up for a doctor's appointment, they refused to pull in my driveway because they did not want to get stuck. And we shoveled the driveway. Now, maybe they should think about that when they buy their vehicles. They better buy vehicles that don't get stuck. Maybe they should get some four-wheel drivers. I called the company and complained, said Amy. Right. Because what would they rather have? Their vehicle stuck in your driveway and they gotta call a tow truck, or Amy falls on the ground and breaks her friggin' neck and they gotta call 911 and the ambulance. I think they'd be better off calling the tow truck. Right? Take a chance. Drive down that driveway. Drive down that driveway. We got a long way to go. Who wants to walk down the driveway? The whole purpose of that thing is to get you to your doctor because you can't get there. Those places that run those things, though, that's all a scam, man. Seriously. Every one of those places is real sketchy. You notice that? They're all sketchy, and the people that work there are sketchy. And they get all their money from the government. Vehicles are a minivan. I heard from a person, one company, about 9 people in a minivan at one time. A lot of the medical ride people have a lot of weird rules, yeah. Because they also got a lot of weird employees. Not just weird rules. They got weird employees along with the weird rules. I've been singing. Children's voices are ringing. Angels' voices ringing too. We cannot eat in the vehicle or drink in there. They will not let you smoke in there. Yeah, those are reasonable rules, though, right there. That's pretty reasonable. I wouldn't want you to eat in my vehicle or drink in my vehicle either. Or smoke for sure. Those are reasonable. That's reasonable. I had bean dip, Joy. Bean dip. Boom, 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 boom. Good. Amy said, but if you're very smart, you could get away with it. I could just tell him my sugar level's going down and I need to eat this Snicker bar. Christy said the last medical transport, I wasn't sure I was going to get home because the guy was kind of strange. People are strange when you're a stranger. People look ugly when you're alone. Women seem wicked. I don't know the other words. Hi, CDC. Why does the message say